Good morning, everyone. Welcome to today's hearing. Today we're going to continue hearing evidence from Ms Blakeman, one of the councillors of RBKC. So would you ask Ms Blakeman to come back in, please? Good morning, Ms Blakeman.
Good morning.
We're all ready to carry on, I hope.
Thank you.
Good, thank you very much. Yes, Mr Millett.
Good morning, Mr Chairman. Good morning, members of the panel, and good morning, Ms Blakeman.
Morning.
Thank you very much for coming back to us. On Thursday afternoon when we broke, we were looking at the LFB's enforcement notices in respect of Adair Tower at the end of 2015. Can we move that topic on a little bit in time, not too far, and go please to TMO 00886-208 at page 75. And what I'm showing you here is the minutes of the TMO board meeting on the 4th of January 2016, where Robert Black's report is discussed. And if you look at the very foot of page 75, you can see paragraph 9.12, which says this: the Chief Executive's report included an update on the Adair Tower fire. The board noted that the company and RBKC were going to be served with enforcement notices by London Fire Brigade in respect of the Adair Tower and Hazelwood Tower. The board would be kept updated. Now, all the board required, upon being informed that an enforcement notice would be served, was to be kept updated, it appears from this. Is that right?
Yes.
Did nobody on the board ask why the deficiencies at Adair Tower underlying the proposed enforcement notices had not been addressed before the fire, or at any rate before the start of 2016?
Well, basically, I can't remember, but I don't think that we had known about the previous deficiency notices. Certainly I hadn't known.
So just to be clear, those weren't brought to the attention of the board by the executive team or by Mr Black?
No.
Right.
Not to my recollection.
Having been informed of the deficiencies, rather than the deficiency notices, but certainly the deficiencies making up the enforcement notices, did nobody on the board ask why those had not been addressed as a matter of urgency?
No. I can't remember.
Do you remember whether the FRA system, the system whereby the management of the TMO would address FRA actions identified in the Fire Risk Assessor's report within a fixed time frame, which is what I mean by the FRA system, did nobody on the board ask why the FRA system had let these deficiencies through the net?
I've no idea.
Right, you don't remember that question ever arising?
No.
Right. Was the board not supposed to hold management robustly to account?
Things like those would go to the Finance, Audit and Risk Committee.
But not the main board?
Well, we used to occasionally get their minutes just for information.
Only for information?
Yeah, but they were very, there's not much on those minutes. I've had a look at them over the weekend.
Right. No. Well, that gives rise to the question, why was the board not holding management, through whichever committee it was, robustly to account for the inactivity or inaction in respect of FRA actions that hadn't been completed, which had given rise to the Adair Tower fire?
Well, I can't answer about FRAs because I didn't see them, but I can answer because I also went over some of my emails in the past, and I certainly raised issues like that in my emails to them.
Yes.
To the TMO.
You as a councillor, but not you as a board member?
No.
Right. Did nobody on the board suggest that the fact that the LFB was now threatening to serve enforcement notices, did nobody on the board suggest that that had indicated that there might be something wrong with the FRA process?
I think it's because of the fire that we expected to have deficiency notices. That was the expectation, I think, of the board.
After the fire?
After the fire,
Yes,
yes.
that's not quite my question. My question is, did nobody on the board ask the question, well, why have we got an enforcement notice, given that we've got a fire risk assessor who's supposed to spot things in advance?
Can't remember.
You can't remember?
No.
Can we go to TMO 00853-181? This is the minutes of a meeting of the TMO board held on the 31st of March 2016, as you can see from the top of the screen. And we can see that you were present. If we look at the list of council-nominated board members, you can see that you're in the list there. And if we go to page 2, at the bottom of the page, you can see that there's something called the presentation of the Chief Executive's report under section 9, if you go to that. It says under 9.1, Barbara Matthews presented the Chief Executive's report to the board. She drew the attention of the board to the progress update on the enforcement notices received in respect of Adair and Hazelwood Towers following the fire at Adair Tower. And then at 9.2, this. Jeff Zitron questioned why enforcement notices had been issued, given the fact that the company had commissioned and had valid fire risk assessments in place at the time of the fire incident. Sasha Jennings explained that the fire risk assessment that had been, even though there were no issues reported by the consultant, and the London Fire Brigade in their fire audit and before the fire incident, the occurrence of the fire had created the opportunity to reassess the acceptable standards, which then led to the issuance of the enforcement notices. It was reiterated that the key areas of focus for the notices were the ventilation in the stairwells and self-closures on all flat entry doors. Simon Brissenden commented on the qualification of the risk assessors being used by the company and reiterated the need to use experienced consultants who could highlight any eventualities as well in their reviews of the properties. And then it goes on, the board agreed that the company needed to reconsider the frequency of the fire risk assessments being undertaken and the installation of door closers. Barbara Matthews confirmed that it was intended to install door closers by the deadline and negotiate an extension of the works required on the ventilation issues. The board requested that a report on the conclusions of the review of the stock should be presented at a future meeting, covering any decisions and recommendations in respect of the fire incident. Now, it looks from the minutes that I've read to you there that the TMO board were told that the fire risk assessor had not identified any concerns before the fire at Adair Tower. Is that right, to the best of your recollection?
To the best of my recollection and what's written here, yes.
Yes. And nor had the LFB identified any such concerns, even shortly before the fire, on the reading of this minute.
That's correct, yeah, from what it says here.
Was that your understanding, doing the best you can with your recollection, at the time of this board meeting, end of March 2016?
Well, I've already said we weren't given the deficiency notices before the fire, so we didn't know about them.
No. Would you have expected to have been told that, in fact, before the Adair Tower fire, the LFB had issued a deficiency notice in respect of Adair Tower?
Yes, certainly.
Yes. Did you find yourself persuaded by what Sasha Jennings had said about, quotes, reassessment of acceptable standards giving rise to enforcement notices in the middle of that first paragraph on that page there?
Well, we had the expectation that the people from the executive team knew what they were doing.
Yes. My point is a slightly more refined one. It seems that Sasha Jennings says here that the fire had created the opportunity to reassess the acceptable standards, which then led to the issuance of the enforcement notices. Were you persuaded by what she said there, namely that the fire had created this opportunity?
Well, presumably, because presumably to have contradicted her would have been to call her a liar.
Indeed. And you don't go... Well, the question I have, though, is you don't go straight, do you, from reassessment of acceptable standards to enforcement? Let me put it a different way. When you realised that there was an enforcement notice, did you not ask the question, or did the board not ask the question, well, what is it that's given rise to that? Surely it can't just be something wrong with the standards.
I can't remember.
Right. Did she leave you with the impression that somehow this was the LFB's fault and not the TMO's fault?
I can't remember.
Or perhaps that the LFB might have moved the goalposts without giving the TMO fair warning about what the acceptable
Possibly.
standards were?
That's possible, yeah.
You say that's possible. Do you recall that?
No.
Right. I've shown you where Mr. Brissenden is minuted as raising concerns about the qualification of risk assessors being used by the TMO and the need for experienced consultants. Did you know who the fire risk assessor for Grenfell Tower was at this time? No. Now, the final agreement, as it appears from the last of the paragraphs I've read to you, is that the board had asked for reconsideration of the frequency of fire risk assessments. If the fire risk assessor had not identified the issues leading to the enforcement notices in respect of Adair Tower, how did the board consider that more frequent fire risk assessments would remedy that?
Sorry, I can't answer that.
Do you not?
No, I can't answer that.
Well, you see, the board came to an agreement that the company needed to reconsider the frequency of fire risk assessments. Why was frequency relevant, given that the fire risk assessor had failed to spot deficiencies, which had led to an enforcement notice?
I can't recollect.
Can we go to TMO 100458083, please? At page 87. This is the same set of minutes, but this is now the matters arising. And if you look at page 87 under paragraph 9.2, which is number 7 in the list there on the left-hand column, with the date 31st of March 2016, you can see that it says, Adair Tower report on the conclusions, decisions and recommendations about lessons learned from the fire incident. And then by whom? Robert Black. Do you remember what happened as a result of that?
The normal practice on the board was to rush through matters arising.
When you say rush through matters, could you explain what would happen?
Well, very little would be mentioned about any of the matters arising.
Right. Do you remember specifically what the upshot of item 7 there was?
No.
Right. Can we then move forward in the year 2016 to September and go, please, to TMO 100151998? This is the minute of the meeting of the 29th of September 2016, where the report that is referred to under paragraph 7 of the matters arising from the 31st of March 2016 meeting is discussed, and it's in the meeting pack for what I'm showing you now, which is the meeting of the Board of Directors of the 24th of November 2016. And the minutes of the 29th of September 16 meeting are at page 5. Just go to that. There they are, and we can see that you were present at the 29th of September 2016 board meeting. And if we go in that document to page 7, we can see item 8, which is the minute of the discussion about Robert Black's report on Adair Tower, Chief Executive's report 8.2. The work at Adair Tower to fit new doors and self-closers had now been completed. An audit had been carried out by the London Fire Brigade following the works. No feedback had yet been received, but no concerns were apparent while the London Fire Brigade was on site. The Chief Executive had visited Adair Tower recently and was very impressed with the work being carried out. Following the fire in a block of flats in Shepherd Bush caused by a faulty tumble dryer, it was asked if residents had been warned about these tumble dryers. An article had gone up in the link detailing the details of the particular dryers. This would also be followed up through work with the RAs and compacts to spread the information. Now, the prosecution or intended or anticipated prosecution of the TMO under the enforcement notices is not expressly mentioned in these minutes. But if we look at paragraph 8.4, we could see a discussion, and it says this: the London Fire Brigade had asked for the names and addresses of all the residents so that they could speak to them about why they called the fire brigade, which was contrary to the stay-put policy operated. The RBKC had been informed at all stages of this investigation, as well as their solicitors. No timeline had been made available from the London Fire Brigade as to when the report would be completed. Now, I've read you a lot of this because I'm trying to provoke your recollection, but do you remember any discussion at this meeting, late September 2016, about the possibility of the TMO being prosecuted by the LFB in respect of the matters the subject of the Adair Tower enforcement notices?
I think that the borough had already been advised that there was no intention to prosecute, but I can't remember the actual date that happened.
Right. It looks from this that the discussion centred on an update, and there's no minuted concern about the prospects of prosecution. Does that accord with your recollection?
If that's what it says here.
Right.
I mean, the minutes were not verbatim records.
Right.
Sadly.
Are you able to help us with why, at least as a matter of record, the board wasn't concerned about a prosecution arising from fire safety deficiencies at Adair Tower or Hazelwood?
It may be because the borough had already been told that there would be no prosecution, but as I said, I can't remember the actual times, dates.
Right. Then let's go to Robert Black's report for the meeting at which these minutes were approved, which is, as I say, the 24th of November 2016 board meeting. That report starts in the board pack for that meeting we've just looked at page 47. So TMO 10015-198, page 47.
So there's no date on that?
No, it's agenda item 10.
Of the November meeting?
For the November meeting.
Right, okay, okay.
And if we look and see where Robert Black's report, this is the start of it, as you can see that page. But if we look on, we can see page 58, item 9, health and safety update, and under 9.1, he gives an update there. And you can see under 9.2, Adair Tower LFB's quotes ongoing investigation. On requesting an update, TMO staff were advised in October that the LFB had temporarily placed this on hold due to internal staffing issues. However, their intention was to resume the investigation in early November. Once the LFB paperwork has been completed on the post-notice audits, they will have another case conference to consider this investigation, and this documentation will be provided to the legal and enforcement team. We're hopeful that a final decision will then be reached. However, there remains no firm timescale for this. Now, just on that, do you recall that as at the 24th of November 2016, the LFB's investigation was still ongoing?
I don't recollect it.
And therefore, there was still the risk of a prosecution.
So I don't recollect.
Right. And then at 9.3, there's a decision or an agreement to appoint legal counsel to advise of any action to take. And then at 10, if we go to 10 at the very foot of the page, onto page 59, and over onto page 59, KCTMO fire policy and strategy, it says this policy is currently being reviewed following detailed discussions with the TMO's Health and Safety Committee. In particular, the main proposed changes include, and then the first is, the need to adopt a more proactive approach to the installation of self-closing devices to flat entrance doors across the stock. Recommendation is for an installation programme over several years. Second bullet, increasing the frequency of the comprehensive fire risk assessment reviews. And third, programme of installation of fire action notices in the communal entrance lobbies of all blocks. And then it goes on to deal with storage and charging of mobility scooters, hoarders, and managed use of communal space. And then it says at the bottom, after the bullet points, the redrafted document will be submitted to the next Health and Safety Committee and will include indicative costings of the proposals. Any proposed changes to the policy will require approval from the board and RBKC. Did Robert Black explain why these proposed changes were needed?
Sorry, was I at that meeting? The November meeting?
We'd only know that from the minutes. But even if you weren't, would you not have read this Chief Executive's report at the time?
Oh, I would have read it, yeah. Sorry, can you go back to the question? I've forgotten the question now.
No, it isn't the question. The question is, did he give you any explanation as to why any changes like this were needed? But let me ask it a different way. Did you ever ask him, or did you ever receive an explanation of why these proposed changes were needed?
I thought that the board had agreed on 6th of January that we would ask for these matters to be investigated.
6th of January 2016.
Yes. Sorry, is that 2015? I'm lost on the dates, I'm afraid.
Right, this is now November 2016.
Yeah.
So did Robert Black ever explain to you, to the best of your knowledge, why these changes were needed?
Well, not directly to me, no. I don't know, he may have advised the board, I don't recollect.
Right. Can we then look at paragraph 11 in this, and I'll take this as quickly as I can. LFB deficiency notice received, and then it refers to the deficiency notice. If while undertaking their audit, the LFB consider there are deficiencies which require our attention, which are not significant enough to warrant an enforcement notice, they will issue a deficiency notice. Just pausing there, was this the first time that you learnt that that was the process which the LFB would adopt?
Yes.
These documents have no legal standing, but the LFB do include a time frame within which they expect landlords to comply, and in the event of non-compliance, there's the possibility that these could be escalated and an enforcement notice served. We've recently received a deficiency notice in relation to the LFB's audit of Lonsdale House, Portobello Court Estate several months ago. And then it says this, just to focus on it. The issue raised relates to flat entrance doors and the requirement for us to undertake regular inspection of self-closing devices on these doors. The tenants' doors at this block were replaced with fully fire-rated, self-closing compliant door sets within the last 4 years, and so we are surprised to have received this notice. Discussions with the LFB's fire safety team are ongoing in relation to these specific requirements. So it looks from this that on top of the potential prosecution for the Adair Tower fire and the changes to the fire strategy, the board are now being told that a deficiency notice had been received in relation to Lonsdale House. And also in relation to door closers. My question is, did this now ring alarm bells at board level with the efficacy of the fire risk assessments and actions arising as a result?
I think, to the best of my recollection, this was also being discussed at the Housing and Property Scrutiny Committee, and Laura Johnson had advised us that there was a full programme going to be or being put in place as we spoke. That's all I recollect.
Right. Did you get the sense that door closers was something of a borough-wide endemic problem?
Well, yes, because Laura Johnson mentioned it.
So you wouldn't be surprised then to see that there was a deficiency notice from the LFB in respect of door closers at Lonsdale House? Probably
not. I don't recollect.
Now, the minute of the discussion of this report is at TMO 00841-883. And just to make it clear, as a matter of record, you were at this meeting.
Okay, good.
And the reference for the minutes for the November meeting at TMO 00886-829, there's no need to go to that, but I've read that into the record. The minutes of the discussion of what I'm showing you now is at TMO 00841-883. This is page 1, and this is the board meeting. And the agenda is at page 2, as you can see. And if you go, please, to page 10 in that run of documents, you can see Chief Executive's report. And under 8.4, it says, the works required by the London Fire Brigade enforcement notices were successfully completed within the extended timescales agreed by the LFB. The fire risk assessments for these blocks were also comprehensively reviewed at the conclusion of the work, and the LFB provided with all relevant documentation. The LFB inspecting officers undertook their post-notice inspection at Adair Tower on 28th of September 2016 and at Hazelwood Tower on 15th of November 2016. Formal notification of the outcome of these inspections was awaited. and then the Chief Executive's report was noted. Now, there doesn't appear to have been any discussion either of the changes to the fire strategy or of the potential prosecution or the deficiency notice for Lonsdale House. Can you help us understand why there was no such discussion?
Well, there may have been discussion, but the discussion wouldn't have been minuted because the minutes were not verbatim records.
No. Do you remember independently any discussion of any of those topics?
Can't remember. Sorry.
And what about door closures?
Sorry, can I just ask you, I mean, if you felt that significant matters had been omitted from the minutes, no doubt that would have been raised at the next meeting, wouldn't it?
Well, in the past, I'd raised the fact that some issues I had raised had not been minuted, and at that point I was told that they were not verbatim records, they were just records of what was agreed. So I'd already challenged that.
Well, it was always open, presumably, to the board as a whole, either to adopt the minutes as they were presented in draft, or to ask to have them corrected or supplemented.
Well, that was open to the board. I mean, it wasn't open to me because I'd already raised it.
No, but someone's got to raise it with the board in order for the board to make a decision about it.
Well, I had done in the past.
Yes, but there was no limit to the number of times you could do it, was there?
Well, the answer would have been the same.
Well, it might have been. It perhaps might not. Do you think?
Well, it would have depended a lot on who'd raised it. If I'd raised it, it certainly wouldn't have been accepted.
Why do you say that?
Well, because most of the things that I said were not accepted at board meetings. That's why they weren't minuted.
Is it your recollection that you were something of a lone voice on the board?
Yes, I put that in one of my statements.
I see. And therefore, is it right that if you had wanted to raise something which you thought was relevant, which had been discussed, and wanted to insert that into the minute, you would be rebuffed?
Well, I mean, I cite as an example my concern about the internal TMO review of the works done at Grenfell Tower, which I had challenged, and that was completely ignored, and I wasn't allowed to speak to it even.
And we'll come back to that topic later. And can you tell us who it was in the main, to whom you would address your suggestions and by whom you would be rebuffed?
Robert Black, relating to the board.
In relation to the board? Yeah. Was that your routine experience?
Well, I mean, I'd given up with the board, frankly.
I'm sorry I keep interrupting, but I'd just like to understand this position. Mr. Black was the chief executive. Was he a member of the board? He wasn't, was he?
No, the board was the non-executives, but the executive and the chief executive reported to the board and attended board meetings.
Well, of course, but I assumed that the board meetings were run by the chairman.
Well, I can only go back to what I was asked about Mrs. Edwards's, the chair of the board, her witness statement that I agreed with, where she said that she felt that the residents didn't run the board. I paraphrase, I can't remember exactly what she said in her statement, but I agreed with it.
But who did run the board?
The chief executive.
But he wasn't on it. Sorry, forgive me.
In practice, as opposed to, we've discussed this before, the theory and the practice tended to be different.
Yes, you have said that, and that was very clear in your evidence on Thursday. If you had wanted a discussion or perhaps even a decision held or taken at a board meeting to be recorded in the board minutes, why wouldn't it be the chairman's decision whether or not the minutes should reflect that discussion or decision, as opposed to Robert Black, who was not on the board?
Well, I can best give you an example. I think there was something that the board agreed which I wanted my name recorded against. And the moment I said I wanted my name recorded against, there was a huge row blew up as to why.
I'm really just trying to get a feel for why Robert Black, to your recollection, was interfering with matters of board governance in respect of a board of which he was not a member.
Because the executive officers reported to the board and they produced the reports. We questioned the reports.
Yes, but the matter of keeping records of the board is a matter for the board, not the executive team.
Yeah.
So why weren't the records of the board solely the domain of the board?
Well, as I said, I'd challenged them in the past and been rebuffed. I don't know if other people
Yes, and
had.
by whom on the board had you been rebuffed?
Nobody, as far as I recollect.
Right, now let's look at what happened a week before this board meeting, on the 17th of November 2016. Can we go to TMO 1001724, please? This is a deficiency notice issued by the LFB in respect of Grenfell Tower, dated the 17th of November 2016, as you can see, and it's addressed to Janice Ray. And if you look at the first paragraph towards the bottom of your screen, it's the last sentence, action to be taken by 18th of May 2017. And if you go to page 5, you'll see the schedule of observations. And I'll summarise these for you on this page and the next. In summary, the LFB wanted action on the following. Under Article 11, you can see multiple actions in the common parts, as they call it. Several fire doors didn't fit fully into their frames, breach in the services duct. Article 17.1, the first one is several fire doors didn't fit fully into the frame. And the second one, the protected route had been compromised by the fitting of doors that didn't close. Flats 44 and 153 were checked and did not self-close. Article 14, this is on the next page, Article 14 twice, emergency routes or exits inadequate in that there were various items stored in the common parts. And again, in the second one, emergency routes inadequate in that the two doors did not self-close. And then Article 8, smoke spread precautions inadequate due to a breach in the services duct on the 8th floor. And Article 15.1, fire action notices not displayed. I've summarised these. Did you see this notice or the schedule of the notice at the time, do you think?
No, certainly not.
Certainly not. You're very clear about that.
Yes, I've known, the first time I saw it was when it was submitted to this inquiry.
I see. So you weren't even made aware of its...
No.
Right.
It would have supported the arguments I was making, that I was having with the TMO and with Laura Johnson about the fire problems at Grenfell Tower.
Yeah. Do you agree that it is, by the middle of November 2016, absolutely clear that the LFB were concerned about the self-closer issue, if I can call it that?
It's clear from this, yes. It wasn't clear at the time. It was clear that I had concerns, the residents had concerns, the matrices, which I agreed with Mr. Thompson and Mr. Daffan, pointed this out.
Yes, and those, to be clear, in chronological terms, were August 2015 and May 2016, yes. Weren't they?
Yeah.
Do you know whether this notice was raised under any other business at the 24th of November 2016 meeting?
Not that I recollect, no.
No. I mean, on your evidence, it can't have been, otherwise you would have known about it.
Well, of course I would.
Yeah.
I would have used it in my submissions to the TMO and Laura Johnson about my concerns and the concerns of residents about fire safety at Grenfell Tower.
Yeah. And does it follow from that answer that it ought to have been raised with the board?
Absolutely, yes.
Can we then go to...
And with the borough.
Can we then go to TMO 100459008, please? This is an email from you on the 23rd of November 2016. That's an important date because it's the day before the board meeting of the 24th of November 2016, the minutes of which we've now seen. And we've seen the ambit of the discussion, which was why I've shown that to you already. And here is your email. And the topic is Grenfell Tower brackets, again, exclamation mark, close bracket. And it says, while Mr. Daffan engages in hyperbole in his Grenfell Action Group blog, it is read by most residents of the tower, and the most recent article causes me concern. Mr. Daffan discussed the fire safety issue with me at a recent meeting, and I did point out that the instructions in the event of a fire had been included in one of the refurbishment newsletters. However, I do take his point that instructions are not permanently available on notice boards, nor in a discreet letter to all residents and in appropriate languages where required, and I am asking whether this can be rectified. And then you set out the content as an extract from the most recent blog, and you can see that he refers to the enforcement order, which dates back to earlier in the year, in respect of Adair Tower. If we go up to page 1, we can see Janice Ray's response to you the next day, 24th of November 2016 at 08:51. And she says, "Dear Councillor Blakeman," copy to Robert Black and Barbara Matthews, "Robert has asked me to respond to your email highlighting fire safety issues raised by Mr. Defan in his blog. With regard to fire procedures in Grenfell Tower, I can confirm that these were included in newsletters to the block, and they are also documented on our website. Further, we do publish regular fire safety articles in the Link magazine to all residents, and we write to all new tenants to outline the fire strategy for their block, the procedure to follow in the event of a fire in their flat, and also a fire elsewhere in their block, and advise them of the London Fire Brigade's LFB free home fire safety visit and how to access this. Additionally, I can advise that we are currently considering a programme of installation of fire action notices, similar to those now installed at Adair and Hazelwood Towers, across all blocks. There has been a difference of opinion amongst London Fire Brigade officers on the value of fitting these notices within a block with a stay-put fire strategy. However, we are keen to be proactive about this, and I can confirm that we will be proceeding with the fitting of these notices at Grenfell Tower. It is likely that this will be completed within the next 2 weeks. However, Mr. Defan appears to be challenging the stay-put fire strategy, stating that this is the wrong strategy and that we should be adopting a one-out, all-out approach at Grenfell Tower. I would emphasise that despite extensive discussions with the LFB and other fire professionals, including our fire consultant and senior consultants from specialist fire engineering companies in relation to Grenfell Tower, at no point has the need to change the stay-put strategy ever been raised. Further, the LFB operational crews continue to be very proactive about undertaking regular familiarisation visits to this block and other blocks on this estate and remain content with the arrangements in place. Finally, with regard to the mention of a fatal fire at Hazelwood Tower 10 years ago, I'm afraid I have no knowledge of this. However, I have requested that the LFB interrogate their records and advise on this. I'm also unclear on the reference to the fire investigation team ordered that the grilles on the fire escape staircase be covered over, quotes unquotes. I can confirm that Adair Tower was regularly audited by the LFB, most recently in the month before the fire took place, and no recommendations were made in relation to the design of either staircase or the lift lobbies. Requirements in relation to these areas was included in the enforcement notices, as it was only following the fire that LFB recommended that changes to the building's original design were required. I hope this is helpful, but please let me know if I can be of further assistance. Now, I read that all to you because it's all important, but this email, as I pointed out, was sent to you at 08:51 a.m. Did you receive this before the TMO board meeting on the 24th of November 2016, which was later in the day? I can't remember. Do you remember reading it?
Oh, yeah.
Before the board meeting?
I don't know about reading it before the board meeting. I doubt it somehow.
Your concern was fire safety, and specifically fire safety instructions to residents. Is that right?
Well, that's what the residents had asked me to raise, yes.
Yes. Do you know why you didn't, at least according to the record we've seen, the minutes we've seen, you didn't raise those concerns at the TMO board meeting?
Well, I may have done, but they wouldn't have been minuted.
I see. Do you recall doing so independently?
I can't remember.
Janice Ray says, or suggests at least, that there was a plan to install fire action notices at Grenfell Tower within 2 weeks. Did you know at the time that was related to the deficiency notice at Grenfell Tower? Presumably not, in light of your last answers. No. Would you have expected Janice Ray to refer to the deficiency notice for Grenfell Tower in her email to you in answering your concern?
Well, certainly if I'd known about it, yes.
No, particularly if you hadn't known about it.
Yes. Absolutely.
Would you have expected her to be candid with you and tell you that there had been a deficiency notice on precisely this?
Yes, but that would have then supported my argument that there were problems at Grenfell Tower about fire safety.
So you agree?
Yeah.
Yeah. And I think it's right just to confirm at this stage, you did not know, or still did not know that before the fire at Adair Tower, the LFB had issued a deficiency notice in respect of that building. No. Now, as you see in the last paragraph, Janice Ray said that the LFB had audited Adair Tower a month before the fire and no recommendations were made in relation to the design of the staircase and the lift lobbies. Did that lead you to believe that the LFB had not identified any other concerns at Adair Tower before the fire in that building?
Well, I hadn't seen the deficiency notice.
Exactly right. And therefore well, let me ask it this way. What did her representations in that last paragraph about Adair Tower and the audit by the LFB lead you to think about what the LFB had thought about Adair Tower before the fire in that building?
Well, I suspect it would have led me to believe that everything was okay at Adair Tower and Hazelwood Tower.
Now, the next board meeting, as I say, was 10th of January 2017. We haven't yet seen the minutes of that. They're at TMO 100469660 at page 6, if we can just go to those. And we can see that you are present as one of the two council-nominated board members there, with Faye Edwards in the chair. If we can go, please, to paragraph 6.4 on page 8. We can see the minutes of the discussion. A member queried whether the London Fire Brigade's LFB's investigation into the fire at Adair had been concluded. The Executive Director of Financial Services and ICT informed the board that the LFB had not yet closed the investigation. The solicitors at RBKC had been briefed in the event of a prosecution. The company had carried out the works as specified in the enforcement notices. The executive team had visited both Adair and Hazelwood buildings to see the completed works. The strategy is being developed to install self-closers to all flat entry doors across all the properties managed. In response to a question from a board member, the Executive Director of Financial Services and ICT confirmed that a fire risk assessment had been completed after the works had been carried out, which showed the improvements from the management actions and remedial works. There were a number of lessons learned from the incident, which would be taken into account. Now, the last sentence of paragraph or section 6.4 there about the strategy to install self-closers to all flat entry doors across all properties managed. Given the lack of self-closers was an issue in the Adair Tower fire, and also an issue, as we've seen now from the deficiency notice in respect of Grenfell, did you get the sense at this meeting that the installation of these door closers across the borough was a matter of the utmost urgency, or not?
Well, I would have done, but Laura Johnson deferred the whole programme, as I recollect, from the Housing and Property Scrutiny Committee meetings that I was at.
Yes. Really, I'm asking you your impression, as best you can recall it, whether the board was given the impression that this was an urgent matter being urgently remedied or not.
I can't recollect.
Do you accept that the board ought to have demanded a tight and detailed timetable for the installation of door closers, rather than accepting the suggestion of a strategy, quotes unquotes, being, quotes, developed, quotes unquotes?
All I can say to that is I suspect the board assumed that the strategy meant that it was going to be implemented.
Right, but how quickly?
Well,
Did you get any sense of urgency?
No.
Shouldn't you have done? Shouldn't the board have taken the bull by the horns and demanded a rapid rollout of a door closer programme across the borough?
The board may have done, I don't recollect.
Don't recollect that? Right. Again, there's no mention here of the Grenfell Tower deficiency notice of the 17th of November 2016 that I've shown you. Do you recall whether this document was mentioned at all in this document?
I knew nothing about it until this inquiry.
Yeah. Can we then look next at the Chief Executive's report for the next meeting, 23rd of March 2017, TMO 100469660 at page 6. This is his report. I'm sorry, this is the
10th of January.
This is the minute of the January meeting. the report is for the 23rd of March 2017, and we need to go, I think, to page 10 in this run of documents. That's the first page, and you can see that there's a synopsis, and item 5 in the synopsis is health and safety, including fire safety, if you can see that. And then if you go to page 15, please, let's look at item 5, second paragraph, or second main paragraph, under Adair Tower LFB's ongoing investigation, quotes, "The LFB's fire safety team leader advised at the regular LFB/TMO liaison meeting in January that the LFB had held a further case conference on this issue in the first week in January, and their conclusion had been that there was enough evidence to prove offences, but also a lot of mitigating circumstances. The question of whether a prosecution would be in the public interest is apparently still to be addressed." Now, if there'd been any doubt at all in your mind about the status of that prosecution, do you accept that it was clear from that report that there was now sufficient evidence for a criminal prosecution over the Adair Tower fire?
I don't think it says that.
Well, it says the LFB's conclusion had been that there was enough evidence to prove offences.
But also a lot of mitigating circumstances, whatever they were.
Right. Well, what was your reaction? Well, do you remember this discussion?
No.
Right. So you don't remember your reaction to
No.
the update about the possibility of prosecution?
No. Was I at that meeting?
Yes, you were.
Okay.
If we go on to page 16, LFB notices of fire safety deficiencies, and there's a long list here, but it says, if whilst undertaking an audit, the LFB consider that there are deficiencies which require attention but which are not significant enough to warrant an enforcement notice, they will issue a deficiency notice. These documents have no legal standing, but the LFB do include a time frame within which they expect landlords to comply. Further, in the event of non-compliance, there is the possibility that these could be escalated and an enforcement notice served. And then this. Since the fire at Adair Tower in October 2015, the TMO have received 9 deficiency notices in relation to the following blocks. Balfour House on Balfour Burley Estate, 5 notices in November 2015. That's about communal storage. Barrington Walk, Lancaster West, about the design, glazed roof. 9 Colville Square, and that's about stay put. Lonsdale House, which is about self-closing devices. Grenfell Tower, self-closing devices. And then a paragraph underneath it, self-closing devices on flat entrance doors. The need to adopt a more proactive approach towards the retrofitting of self-closing devices on flat entrance doors throughout the housing stock was recognised as part of the thorough review of our fire policy and strategy. This is necessary to satisfy the LFB's requirements, as they have confirmed that they consider our previous policy would take too long to ensure 100% of tenanted doors are fitted with these devices. The change should also reduce the likelihood of further LFB deficiency notices being issued on the basis of absent self-closers. The TMO is therefore currently in discussion with RBKC about the possibility of introducing a 3 or 5 year programme to install self-closing devices across the stock. Now, there's a lot of text there that I've read to you, but a number of questions which arise. First of all, 9 deficiency notices. Surely that was, to the board, a red flag for the TMO that something wasn't quite right with how the TMO were going about managing fire safety in their stock. Do you accept that?
Yes.
Do you remember that?
No.
You don't remember being impressed or depressed, perhaps, that there were 9 deficiency notices?
Probably, but I couldn't.
Did you note that the final bullet point related to Grenfell Tower and the maintenance of flat entrance door self-closers? Something close to your heart?
Yeah, I may have noticed that, I don't know.
Right, you can't
remember.
Right. And I've shown you the paragraph under the heading self-closing devices on flat entrance doors. Given that there had been issues or problems with self-closers in Adair Tower, to such an extent that the LFB was still considering a prosecution of the TMO, Was anybody on the TMO board saying 3 to 5 years, and certainly 5 years, is far too long for this plan?
I have no recollection, but it was probably because the TMO didn't have the funds to do it.
Did nobody think to go to Laura Johnson and say, 5 years is certainly too long, it must be shorter, we need the money?
Well, I know now that Barbara Matthews did say that
Right.
to Laura Johnson.
Was there any discussion on the board about the board doing that,
Can't remember.
rather than leaving it to the officers?
There may well have been, I can't remember.
Right. Did anybody on the board ask how this apparently generic problem, penetrating the entirety, it seems, of the TMO stock at the time, had been permitted to arise?
Possibly. I can't remember.
Can't remember. Did nobody actually ask, well, are these fire risk assessors really competent to do their job, whoever they are?
I don't think so, no.
Did nobody ask the question, is your system for closing out fire risk assessment items actually working?
I have no recollection.
Did anybody raise the question of the regularity of inspections of self-closing devices or the maintenance programme in respect of those
I
devices?
don't remember.
Or how you were going to stop tenants pulling them off or breaking them or stopping
Again,
them?
I don't remember.
No. Right. Can we turn to a completely different topic, which is the complaints process? Now, in your time as councillor, Ms Blakeman, it's right that you raised a significant number of complaints and concerns on behalf of residents of Grenfell Tower, didn't you?
Amongst other residents, yes.
Amongst other residents or amongst other properties?
Amongst other blocks, properties, estates, sometimes right across the whole borough.
Yes. I'd like to ask you about your understanding of the process by which residents could raise fire safety concerns before we look at specific concerns and complaints that you did raise on their behalves. Can we start, please, by looking at your statement to the inquiry, RBK 30544661, page 16, paragraph 84. And you say there, under the heading, communications with residents, answering the question, what system was there, if any, for residents to express their concerns and views about fire safety? You say this: in theory, residents could express their concerns and views to the KCTMO, to Ryden during the refurbishment, to RBKC through the GTLA and the Compact, to the Lancaster West Residents Association, to ward councillors via the Grenfell Action Group blog, and directly to cabinet members and the Member of Parliament. Now, you've described Lancaster West Residents Association in paragraph 85, if you look a little bit below that in the fourth line, as rather inactive at the time. What was the time that you're referring to there?
Well, that whole period of the refurbishment of Grenfell Tower.
Right,
And
see.
before.
When did the Lancaster West Residents Association cease to be active, or cease to be rather active?
I don't recollect when they ceased to be active, because they were not very active throughout the whole period, as I recollect.
Right.
Towards the end, they then had an election and a new committee came in, which was much more active, but that was very late in the day.
Was it open to Grenfell Tower residents to join the Lancaster West Residents Association?
Well, they could have done, yes.
And presumably they could have revived it as well, if they thought it was inactive.
It would have been like turning round a large tanker, because they wanted to be able to negotiate with the council and Ryden and the TMO about the works to Grenfell Tower, if they at the same time had to revive the Residents Association that covered the whole of the estate, which is the biggest in the borough. They would have not had time to raise their issues about Grenfell Tower.
I see. So is that why the revival of the LWRA was actually not considered as an option?
Yes.
Right. Can we then turn to something called the Mamoli Report? Do you remember that in 2009, Maria Mamoli, an independent adjudicator, completed an investigation report on long-standing complaints about the TMO?
I was told about that. I was not involved at the time.
Did you read it at the time?
No.
You didn't?
No. I was not involved in housing at that time.
All right.
I was told about it by residents.
Did you come to learn of the Mamoli Report?
Yes.
When was that? Do you remember?
Oh, crikey. Well, it was during the time when the residents were up in arms about the refurbishment of Grenfell Tower.
So from 2012, Is that I mean, I'm guessing.
No, the
Could you help?
refurbishment didn't start in 2012.
Well, the discussion of it did.
Yeah, but that was just approval of the principle.
Well, can you tell me, though, when, to the best of your recollection, you first became aware of the Mamoli report?
It was probably around about 2014, 2015.
Right. Let's look at it. IWS 401462. There it is. That's its first page. And on page 3, we have an executive summary. And if we look at the first paragraph, it says there are a number of tenants, leaseholders and freeholders within the Borough of Kensington and Chelsea who feel aggrieved that their problems have not been resolved by the TMO despite several years of complaining. And then if you look down to the bottom of page 3, we will need to scroll up for it, you can see the summary of the main recommendations. And if we scroll through those, you see on the bottom of page 3, customer care / relations, and then on to page 4, customer services, complaints, repairs, major works and service charges, and over on to page 5, governance issues, corporate policy, financial issues, follow-up and review, etc. And page 43 and onwards are the detailed recommendations. You say you first became aware of this or read this document in 2014, you think?
I became aware of it. I didn't read it. I didn't have a copy of it.
Right. When do you think you first read it?
When this inquiry started.
How did you become aware of it? Do you remember?
No, residents mentioned it to me. And so I think it was referred to at the board at one stage as well.
I was going to ask you, do you remember when it was referred to the board?
No, it was referred to at the board, at a board meeting that I was at.
Yes, do you remember when that was?
No. Probably quite early on during my service on the board.
Right. Do I take from your evidence so far about this document that none of the main recommendations I pointed out to you on pages 3, 4 and 5 of this document informed the TMO's work when you were a board member?
I have no idea, because the report was 2009. I joined the board right at the end of 2012,
yes.
By which time I understood that the Mamoli report recommendations had been implemented.
When you joined the board in that year, did somebody tell you there was a Mamoli report, but not to worry about it because the recommendations had been implemented?
No.
So when you say, by which time I understood that Mamoli report recommendations had been implemented, when did that understanding first come into your mind?
Well, it didn't sort of occur in one go. It kind of occurred over the years as I was on the board.
Right. Can we just try and break this down a bit and see if we can get to what happened? So you say it was the residents who first brought the existence of the Mamoli report to your attention.
Yes.
So does that tell us that when you joined the board and thereafter, until the resident told you about it, you had no idea about it? And no, it was never discussed at a board meeting?
No, it certainly wasn't discussed at the board when I was there.
Do you remember who it was who first brought the existence of the Mamoli report to your attention?
I think it may have been Mr. Montero from World's End.
Oh, I see. Not somebody from
No.
Lancaster West or Grenfell. And when he brought it to your attention, did you go and see if you could find a copy?
No.
Why is that?
No time.
No time. Did you ever see the adjudication judgment, draft or final, of somebody called John Butler of July 2009?
No.
Did you ever see a follow-up document, which was the appendix to that document, about what should be done by the TMO in response to the Mamoli recommendations? No. Do you know at all, even now, what role the board of the TMO played in following up on the Mamoli recommendations and the Butler report?
I only know that they got a new chief executive and they got rid of some of the members of the actual resident members of the board. But all that was before my time on the board.
And when, in 2014, you became aware of the existence of the Mamoli report, did you go to any other member of the board and say, I hear that there's this report from 2009, I'd like to look at it, please, because I'm getting complaints about it,
No, I wasn't getting complaints about it. People were harking back and saying what they needed was another memorial report.
I see. So is it right that nobody was saying to you at the time, the memorial recommendations have not been carried into effect so far as we can see? No. I follow. Can we go to MET 3045751, please? This is your police statement, and can we go to page 12 in that, please? This is your 28th June 2019 Metropolitan Police Statement, page 12. Second paragraph from the bottom of the page, you say this: I would say that generally the TMO treated the residents and ward councillors with a fair amount of disdain. Any issues raised were deemed an exaggeration, and it seemed that the TMO believed that ward councillors were being pushed by the Grenfell Action Group as we didn't like what was being written about us. This was not the case. Although some of the things that appeared on the GAG blog about the ward councillors were unjustified, other matters raised by GAG were absolutely justified. However, as I mentioned above, GAG's apparent belief that if the ward councillors had opposed the school, it wouldn't have been built was unrealistic. What led you to believe that the TMO treated both residents and ward councillors with disdain?
Because they did.
No, but what led you to believe that?
Well, for example, the response to all my complaints.
Was that attitude always prevalent in your experience as a board member?
If the complaint was simple and it could be resolved, then it would be resolved. But, for example, the mattresses that I submitted, we discussed this on Thursday, that their responses to me tended to be bland reassurances rather than active responses.
Now, can we go to TMO 008854441? This is a TMO Operations Committee meeting on the 1st of October 2014. And we can see that you were there as present. And if you go to page 3 and look at agenda item 7, please, performance update, you can see that there was a discussion about the TMO's performance. And if we go over to page 4 at paragraph 7.8, it says, Deborah Price questioned how issues raised by residents could be addressed which had somehow bypassed the complaints process, yet resolved. Committee members thought that there was some ambiguity around how an inquiry progressed to a formal complaint, although it was confirmed that these were also responded to. Simon Brissenden felt that there was a grey area at the start of the process, as it could prove difficult to establish when a complaint was originally raised by stage 3 of the process. And then at 7.9 it says, the committee also questioned whether there was any guidance on the online complaints process. Confirmation was given that the complaints procedure was being reviewed and committee members' concerns would be addressed. Do you remember whether there was any substantive difference in how a complaint or an inquiry was treated by the TMO? In other words, any difference between treatment of a complaint on the one hand and treatment of an inquiry on the other?
Well, at that stage, I don't think I realised that they were treating some issues as inquiries and others as complaints. So I can't answer that.
It says at 7.8, committee members thought that there was some ambiguity around how an inquiry progressed to a formal complaint. And Simon Brisson said that there was a grey area. Do you remember yourself feeling that the complaints process was confusing as between what is properly a complaint and what was properly an inquiry, as defined?
Well, I asked for the KPI to be changed to ensure that councillors' inquiries were included in the KPI, because they weren't. And
That's KPIs.
Yeah.
From the residents' perspective, was it your impression that there was confusion about which process to use, an inquiry process?
Oh, yes, a huge confusion.
Right.
An awful lot of residents didn't understand the TMO's complaints process at all. That's why they came to us.
I see. Can we look, please, at TMO 00879-692? This is the TMO complaints policy, which was revised on the 30th of July 2015 and agreed by the TMO board, the board, including you, on the 10th of September 2015. The earlier version, I should just tell you, was dated 2010. That's the document, and it was presented to the TMO Operations Committee on the 30th of July 2015 in accordance with that notation. And we see those minutes at TMO 0088590, please. I'll just show you the first page of that. We can see that these are the minutes of the Operations Committee on the 30th of July 2015, and you are present as the council-appointed board member. See that? And if we go to page 5 in the document, paragraph 10.5, we can see that it says, under the heading Revision of the Complaints Policy at the top of this section, 10.5, Brendan Tracy sought clarity on whether the provisions around the use of the complaints procedure by KCTMO board members, councillors, MPs and other elected representatives to make complaints on behalf of their constituents would not be considered as a conflict of interest, particularly for board member. Fola Kofidia Oke confirmed that the provisions of the clause would result in a conflict, as board members could not use their position to act on behalf of residents, and any board member's involvement in such matters would be limited to signposting residents or making no reference to their position. Janet Seward agreed to delete the wording from the revised policy. What was the concern, do you remember, about TMO board members making complaints on behalf of constituents?
I don't remember the concern. I do remember being challenged by the chief executive at one board meeting about my perceived conflict of interest, and I remember answering that by saying that I was elected to represent the interests of Nottingdale residents, and that would always be my priority.
Was that in early 2016 in relation to the TMO investigation of the
No, that was much earlier than that.
Much earlier than that. Do you remember what that was in connection
Nope.
with? No. Do you remember this meeting and what this concern was about board members making complaints on behalf of their constituents?
Unless it related to me, I don't know.
By removing the wording to this effect from the policy, was it agreed, do you remember, that the board members could not make complaints on behalf of their constituents if they were also a councillor?
I remember having a meeting with Fola Kafadir about it, and I remember advising both the Labour group and the council, I think, that in that case, if this were the case, then no councillor who had any TMO property in their ward could actually be on the board.
Right. And what did you think of that?
Well, I thought that was absurd.
That was what I was going to ask.
There was only about one ward that didn't have any TMO property in it.
Well, I was going to ask you, surely this conflict identified in this minute here was inherent in the idea that councillors could sit on the TMO board?
Yeah.
So if that's the case, why was it a conflict, did you understand, for a board member to support or assist with a complaint by a resident about the service provided by the TMO?
Well, I didn't think it was a conflict.
Who was pushing the idea that this was a conflict?
Robert Black, I think.
But he wasn't on the board.
No.
So how could he push it? What power would he have to?
Oh, sorry, no. He would have pushed it as chief executive.
But it wouldn't have been in his gift to call out conflicts like that, would it? That would be for the chairman or the rest of the board.
I think conflicts were called out by members of the executive from time to time.
What did the rest of the board think of this idea?
I'm not sure they understood it.
It was the idea of having a TMO board, comprised in part at least of people like you, that the board should be impartial and independent, supervising the work of the executive officers.
If you look at the role of councillors under the council constitution, one of our roles is to sit on boards as determined by the council.
Yes.
And my understanding was that councillors sitting on the board of the TMO were to ensure that the money was spent properly.
But was it not also to make sure that the work done by the executive team was done properly?
I've no idea.
Did you not understand?
I was never given any induction or any explanation as to why I was put on the board.
No.
Only that the Labour group had one place on the board and I was nominated to it by the Labour group.
Yes. I'm just trying to get to the bottom of your understanding of what the role of the board was. Was it your understanding that the role of the board was to be an impartial and independent organ supervising and scrutinising the work of the executive?
No, the work of the TMO.
Yes, the work of the TMO executive.
Well, no, the work of the whole TMO, not just the executive.
Yes, you were on the board. And did you understand that the role of the board was to supervise and scrutinise the work of the executive team?
Or to scrutinise and to challenge when they felt it was not being done properly.
You did think that?
Yes.
Yes. And therefore, that being the case, how could there possibly have been a conflict in taking up causes raised with you by residents, which had arisen out of the way in which the TMO executive team had done their work?
Well, I never thought there was a conflict. In fact, I asked the borough solicitor about it.
Can you enlighten us as to why anybody would have thought that there was a conflict of this kind as identified or reported in this minute?
Well, I gather that company law says that when the board has made a decision, everybody is bound by it, whether they agree with it or not.
No, that's not quite an answer to my question. Are you able to explain the circumstances in which this notion of a conflict had arisen?
Well, I knew that they were very upset with the way I was behaving.
They being whom?
The board.
Why were they upset? Why would the board be upset?
Because I was submitting complaints to the TMO.
To your way of thinking, did you think that the rest of the board didn't understand that their roles to be an impartial and independent organ supervising the work of its officers?
Some of them may not have understood that.
Did you get the impression that that was the case?
Yes.
Who did not understand that role?
It would depend. I can't recollect, but certainly the council nominees, certainly the Conservative council nominee, the council nominees, I don't know, I can't remember.
Was it your impression from time to time that members of the board would, as it were, close ranks
Yes.
with the TMO executive?
Oh, absolutely, yes.
And what gave you that impression
The way I was treated.
in relation to complaints?
Yes.
Now, let's go...
Are we to understand then that the tenant members of the board, who were, after all, in a majority, closed ranks against you?
Some of them did, yes. Not all of them, but the majority of them.
And did you have any understanding as to why they did that?
Well, they were trained in being board members by the executive. I wasn't.
Well, what sort of training did they have?
Well, I don't know because I wasn't included in it.
I see. Yep, thank you.
Were there any other councillors who shared your view about other board members not understanding the role of the board as an impartial and independent organ?
Yes.
Who were they?
The members of the Labour group. Those who bothered, who understood what was going on, yeah.
I see. It sounds to me as if the impression that you're telling us about split on party lines.
Yeah.
Is that right?
Yes.
I see. Mr. Chairman, I've got one document before a natural break.
Yes, very well.
Thank you. Now, can I go to your statement, please, at RBK 305461, page 21, paragraph 111. You're dealing with complaints by residents in this section, and you say this: some fire safety issues were mentioned from time to time on the Grenfell Action Group blog. On occasion, I would suggest to the Chief Executive, Robert Black, that the TMO should take the blog seriously, but he told me that no one at the TMO ever read it. I do not believe that this was true, but had no grounds to challenge that assertion. Why did you suggest to Robert Black that he take the GAG blog seriously?
Because a lot of the complaints that they raised, particularly about fire safety, were quite valid in my view.
Even though, from time to time, they were quite rude about you?
Yes. Yeah, I mean, that was one of the reasons why I wasn't convinced when Robert Black told me that nobody at the TMO read the blog, because from time to time, members of the executive would say to me, you've only submitted this complaint because you don't want the GAG to write something nasty about you.
Is that why you believe that the TMO officials did read the GAG blog, contrary to what Robert
Yes,
Black was
yeah.
telling you? Did he not tell you that the TMO had blocked the GAG blog on their systems sometime in 2014?
No.
That was the effect of Claire Williams's evidence to the inquiry.
Yeah, well, that was the first time I heard it.
Right. That wasn't that you didn't know that.
No, I didn't know that.
Right. Did Mr. Black give you the impression that staff at the TMO did not read the GAG blog because they didn't take it seriously? Or did he give you the impression that they didn't read it because they didn't want to read criticisms of the TMO, however colourfully expressed?
Both.
Both. Mr. Chairman, is that a convenient moment?
Yes, I think it is. We'll have a break now. Ms. Blakeman, we'll resume at 25 to 12, please. And again, I have to ask you not to talk to anyone about your evidence while you're out of the room. Thank you. Twenty-five to 12, please, Mr. Millett. Would you ask Ms Blakeman to come back in, please? Right, Ms Blakeman, I'm sorry we kept you waiting a bit longer than I'd suggested. I think there was a technical problem.
So I heard.
Anyway, ready to carry on now, I hope. Yes, Mr.
Yes, Mr. Chairman. Ms Blakeman, just one or two questions arising out of the evidence you gave before the break. First, on those occasions when you weren't satisfied that the minutes reflected the discussion or decisions held or taken at a board meeting, did you not seek at the next board meeting, when looking to adopt the minutes, to have those minutes corrected, or at least your objection or correction minuted?
Well, as I said earlier, I had at one meeting tried that, and I was told that only the decisions would be minuted, so there was not a lot of point in continually raising the same matter.
Could you not have insisted that your objection itself be minuted?
Well, that would have provoked another long conversation. If you recollect, I also said that there was one occasion when I asked for my dissent to a decision to be recorded, and that prompted a huge attack on me from Robert Black.
Yes, I mean, you do realise that the Constitution, the Articles of Association of the TMA, require full and accurate minutes to be maintained, don't you?
Well, I mean, the Articles of Association, they could have removed me at any time when they wanted as well.
And if you had a huge attack prompted by this discussion directed at you by Robert Black, was your response to Robert Black not simply to say, Mr. Black, you are not a member of this board?
No, I'm quite used to being bullied by men.
Well,
Well, you could perhaps have asked the chairman to point out to Mr. Black, no doubt very politely, that he had no lockers to make, no standing to be making any comments
in theory,
on a matter
yes.
of that kind.
In theory, yes, but I doubt that the chair would have had the courage to do so either.
well, that brings me to the next question. Did you ever raise your concerns about this way of carrying on corporate governance with the chair?
I had a meeting with the chair quite late in my board membership, at which I expressed some concerns about the way I was treated. Because at one stage, I mean, the leader of the Labour group was asked to remove me from the board, and he refused to do so.
Yeah. What was the upshot of your discussion with the chair about?
I think we then had a debate about the minutes, and then there was a fire, and
Right. So this was late on.
yeah.
I see. I mean, given that the board had a majority of residents, as a matter of constitution at least, why would the board, as you said before, regularly close ranks with the executive team?
I don't know. You'd have to ask them.
But I'm asking you, though, what your perception of that was.
My perception was that, well, there were probably a couple of board members that were sympathetic to some of the issues I raised. One of them was then not re-elected.
Right. Were the residents there, the residents,
yes.
who are on the board, not sympathetic to the concerns that you raised?
Not all of them, no.
Really? Can we then turn to some specific fire safety related complaints and concerns that you raised on behalf of residents? Let's begin with TMO 00848-807. And this is the minute of an EMB meeting on the 15th of May 2012. And we can see from that document, the first page of it, that the chair is Robert Bryans, the secretary is Doug Stewart, number 6 present is Edward Daffon, and we can see that you are in attendance there, thank you, as a co-opted board member, as member 13. You see that? If we go, well, first, when were you first co-opted to the EMB itself? Do you remember, or was that on a meeting?
I think it was about 2010.
2010.
I think so, when I was elected.
Right.
To the Notting Dale. And my predecessor had stood down, I think, in 2010.
Right, but you were co-opted to the board the EMB board
Yeah.
in 2010?
I'm pretty certain it's 20.
Right, okay. Let's go to page 4 of this document. Agenda item number 8, please. Grenfell Tower proposal, and it's a long piece of text. I'm not going to read it all to you. If we look down through it to the 5th paragraph down, which starts in the minute, it says, RB asked the board if we should have a Grenfell committee. And you'll see that.
Sorry, was it?
It is on page 5, and we are on page 4, which is the source of the confusion. If you go to page 5, 5th paragraph down on that page, RB asked the board if we should have a Grenfell committee. DS said it's a good idea, and other members agreed. RB confirmed EMB will discuss and put names forward to be on the committee, and this committee will just concentrate on the tower. RB is Robert Bryans, the EMB chair, yes?
Yes.
Yes. And we saw that Edward Daffan was there. Do you remember whether he agreed with this proposal?
I can't remember.
Do you remember any opposition by Mr. Daffan to this
I
proposal?
can't remember. It's too long ago.
Is Mr. Daffan's opposition something that you would remember?
Not necessarily.
Now, we're not aware of a Grenfell committee, so to speak, having been established at this time either within or outside the EMB.
That's correct.
Do you know why that was?
No,
Do you know what happened to this proposal?
I can't remember.
Right. Can we then go to your second police statement, please? MET 3045751. Yes, thanks. And on page 10, you refer there under the heading Grenfell Tower Compact to that compact and it asking to be recognised as a residents' association. And you say in the third line from the end of the second paragraph there, the paragraph starts, an example of this is when the residents try to form their own residents' association. In the last three lines, you say, I reiterated the request for them to be able to form their own association, but the TMO again refused. As a result, the residents then went to their Member of Parliament, Victoria Borwick, for help, who arranged a meeting between them and the TMO. Do you know why the TMO was resisting recognising the Grenfell Compact at this time?
Well, they always said it was because they should have joined the Residents' Association.
And what did you think of that?
Well, again, I didn't think that the Residents' Association was appropriate because the Residents' Association tended to concentrate purely on arranging social events.
Right. You say that they said because they should have joined the Residents' Association. What was your understanding about the real reason why the TMO refused recognition of an association, a compact?
Real reason? Because they said they should have joined the Residents' Association.
How would that have helped?
Well, it's this question of theory versus practice. In theory, residents' associations raise issues on behalf of their residents. In practice, this particular residents' association was pretty moribund, and they tended to focus on arranging social events.
So, if that was the practice, what was the reason? What was the justification? Let me put it that way, for the TMO refusing recognition.
I don't know. You'd have to ask them.
Well, I'm asking you for your perception.
My
of the
perception
justification.
was because they felt that they should have joined the residents' association.
Why did Victoria Borwick's intervention help?
Well, presumably because she was a member of Parliament and she was a Conservative. She was also a councillor at the time. And I actually knew her quite well, and I broke at the first meeting.
And you did, and
Yes.
that is certainly correct. You say, presumably because she was she was a Conservative.
Well, and a member of Parliament.
Yes. Why did that have anything to do with it?
Well, I think she had more influence to bring to bear on the TMO than I had.
Right. Was it your understanding at the time that unless Victoria Borwick had lent her assistance, the TMO would not have moved on the point?
I suspect they wouldn't have moved, yeah.
Right. Now, in your statement, you refer to this as an example of where Mr. Daffon, had unrealistic expectations of ward councillors. I don't need to show you the reference of that. Well, in fact, it's in the first paragraph on this page. You say that he had an unrealistic expectation as to what opposition councillors could actually achieve on their behalf. Why was it unrealistic for Mr. Daffon to come to you for help, seeking recognition for a residents' association?
It wasn't unrealistic for him to come to us. It was possibly unrealistic for him to expect that we could get what he wanted done.
And given that, as you've explained, the Lancaster West Residents' Association was inactive, or active only to the extent of organising social events, and given that the Grenfell Tower refurbishment project was not estate-wide, surely it was an entirely realistic expectation, or at least a realistic and justified request for the residents of Grenfell Tower to be able to form a compact.
Yes.
And therefore, if it was a justified request, why was it unrealistic to expect that might
Because
be
they didn't
forthcoming?
ask to form a compact, they asked to form their own separate residents' association.
What difference would that make?
The difference is that there was a residents' association for the whole estate, and I don't think that the TMO fancied breaking down estates into different residents' associations.
Well, why not, given that...
Well, I don't know, because sometime previously there'd been an attempt by the residents on one side of the estate to break away from the other residents' association on the other side of the estate, and that was turned down too.
Right. I mean, given that the refurbishment affected the tower and not the entirety of the estate, why wasn't it a realistic expectation that the TMO would entertain the existence of a group devoted to protecting the residents' interests?
Well, I thought it was a realistic expectation, but it was turned down.
Right. Now let's go to page 5 in this document. If you look at the third paragraph from the bottom of the page, it's a long paragraph, you say in that paragraph, I was not involved in the day-to-day management of the project, nor with any of the changes that were made during the life of the project. For example, I was not aware of changes to the materials specified for the refurbishment of the tower. I have no expertise in such matters. Since the fire, I have reviewed the documents in my possession. I was aware that the residents were invited to choose what cladding they would like to see added to the building. They were told that the purpose of the cladding was to improve the look of the building, as well as to provide better insulation for the flats. The residents were shown different samples of cladding and approved zinc cladding, although I do not believe that any of the residents were experts, and I assume their decision was based mainly on aesthetics. The zinc cladding was subsequently changed to aluminium cladding, but this was not specifically brought to the attention of the TMO board or the TMO Operations Committee at the time. I do not know if planning permission was required for the change. Now, you suggest here that you became aware that residents were invited to choose, your word, choose.
Yes, I was told that they could have a choice.
Yes.
But the choice seemed to be related more to colour, but what they chose was zinc.
And you say that because of consultation in 2012?
No, I was told that by the architect Andre Cushel.
When were you told that?
Oh, God. In passing at some meeting or other, after some meeting or other, very early on.
Right. What was the basis of your understanding? Well, sorry, let me start a little bit earlier down the track. You say that after the fire you reviewed documents and were aware that the residents were invited to choose what cladding they would like to see added to the building. Is that right? That, in fact, it was after a review of documents that you thought the residents were given the choice?
I think the actual cladding, yes. Not the colour. The colour, I knew about the choice that they were given for the colour.
What was the basis of your understanding that they were given the choice about the cladding?
I think it said so in one of the newsletters, but I can't actually recollect now.
Did you see any document which led you to think that the residents were given a choice about the switch from zinc to aluminium?
No, they weren't.
No. Were you aware of any effort by the TMO to tell or inform the residents or ask the residents about the change from zinc to aluminium?
No, they were not told.
Or the reasons for that change?
No, they weren't told. There was no consultation on that issue whatsoever.
Did you realise that at the time?
No.
You didn't?
It was after I looked at the documents and I saw in one of the newsletters a very, very tiny little bit that said that it was aluminium cladding, not zinc.
But that was by way of information, not by way of...
Yes. Yeah, that was by just telling them.
Yeah. Can I show you a document, TMO 008-79771, please, at page 17. This is an extract of Peter Madison's notebook. And on this page, on the right-hand side, you have an extract, or an entry, rather, for February 2013, 4th of February 2013, at the top right-hand corner. And halfway down the page, in the middle, he has written that you had a view, it looks, on the design or colour of the cladding and had been talking to the planners.
No.
Is that right?
No.
Did you, as a matter of fact, have a view on the cladding, either about design or colour?
I was told, I think, again by Mr. Cushell, that I could have a look at the choice of cladding and make a decision. And I decided it was nothing to do with me, it was to do with the residents. So I didn't.
Right. Do you recall speaking to Mr. Madison on this subject at that time, early February 2013?
If I did, I would have said to him that I proposed not to make a choice myself because it was up to the residents.
Right. Do you remember speaking to anybody at Leadbitters on the subject of the design or colour of the cladding?
No, because Leadbitters weren't doing the tower.
Well, in February 2013, that was still a moot point.
Well, I was told by Mr. Anderson after a board meeting very early on that Leadbitters had quoted 11 million for the project, which meant that they probably didn't want to do it.
But
So I wouldn't have talked to Leadbitters about the cladding.
all right. Had you spoken directly to the planners on the subject of cladding, whether design or colour?
No.
Did you have any input at all into the planning decisions? For
Only
Grenfell Tower?
the main planning decision, which was approved by the planning committee, when I opposed it on behalf of the ward councillors on the grounds of overdevelopment of the site. But that was when the initial planning permission was agreed.
I see. So you opposed the development of Grenfell Tower altogether?
Eventually, we opposed it on the grounds of overdevelopment because they decided to build flats as well, and we felt that that constituted overdevelopment.
Right. And coming back, though, to February 2013 and this note, do you recall any discussion about or having a view about the material of which the cladding was to be made?
No.
So no discussion about zinc or ACM?
No, absolutely not.
Right. Can I then turn to a different topic, which is consultation with the residents about the Ryden tender? Can we look, please, back at your police statement again, MET 3045751, and look at page 5. In that paragraph, where there's a heading, Grenfell Tower refurbishment, it says in the second paragraph there, my ward colleagues and I, do you see that? Mm-hmm. My ward colleagues and I attended several of the consultation meetings held with residents of the tower before the refurbishment began. I was also a member of the subcommittee which recommended the bid from Ryden, further to the advice of the consultants commissioned by the TMO. During the tender process, Mrs. Edwards and I, as the resident representatives, interviewed the resident engagement officer of each of the shortlisted contenders. Mm-hmm.
Correct?
Now, in that context, I want to ask you about that. Can we look, please, at TMO 1005311 at page 3? This is an email from you to Peter Madison at the foot of page 3, 21st of February 2014, in the context of discussions with the TMO about the then current tender for the project, to ask if there would be one or more residents on the interviewing panel. Can you
Yes,
see
I
that?
had been told earlier, when I agreed to go on the panel, that there would be 2 resident representatives on the panel.
Now, when were you told that?
When I agreed to go on the panel,
I see. And when was that? Do you remember?
I think it was at or after a board meeting.
Right. So if you look at the response, which is on page 3, higher up page 3, in fact, it starts at the foot of page 2. It's the same day. Foot of page 2 over to page 3. Peter Madison comes back to you. Copy to Claire Williams. Dear Councillor Blakeman, top of page 3, thank you for sending this across. And then in the last paragraph, he says, yes, we hope there will be a tenant and a leaseholder involved in the interviews. If you can please hold the full day for the time being, we will firm up the times in due course. Mm-hmm. Were you aware of any discussion about including residents in the interviewing panel before your email that day?
I had been told that there would be 2 resident representatives on the panel when I agreed to go on the panel. I didn't know it was conditional at that stage. I was told for definite that there would be. I was only later told that there might be.
Right. Had there been any attempt to include residents in the decision-making about the refurbishment before February 2014, to the best of your recollection?
Well, only through the consultation meetings and the
Right.
drop-ins.
And when I say decision-making in the tender process?
No.
Did you explore what arrangements the TMO had put in place for ensuring that residents of Grenfell Tower had been or could be properly represented in scrutinising the tender? And
Well, only that I was told that 2 resident representatives would be at the panel.
Yes, at the panel, on the panel. My question is, did you go into what arrangements the TMO had made to make sure that those residents who were going to be on the panel were fully briefed?
No.
Or given all assistance that they needed in order for them properly to exercise their powers as representatives of the people living in the building?
No, we weren't. Neither Mrs. Edwards nor I, to the best of, Mrs. Edwards, to the best of my recollection, me certainly to my recollection, was given no information about the panel other than that we would be invited to interview the people who'd sent bids in.
Yes. Do you know where the tender had got to at this point?
I don't think so.
Right. Did you ask?
No.
Can we turn then to the question of concerns raised by residents during the refurbishment, particularly in relation to fire safety? MET 41526, please. And if you look at the foot of page 1 of this email run, I'll wait for it to come up. This is an email from Emadent Code to you on the 3rd of January 2015, saying, for the record, I'm not responding to this unless you ask me to. And this below is an email from GTLA to her as the first recipient and to you as the second recipient, and then copied to a long list of people. And if we go to page 2 in the email run, it starts with the subject, improvement work on existing smoke extraction and ventilation system which links to the fire alarm under the Grenfell Regeneration Project. Dear Councillor Dent Code, season's greetings from Grenfell Tower Leaseholders Association. We request the recipients of this email for their attention, as this is a very serious matter for us all as residents of the Lancaster West Estate and the Grenfell Tower. I'm writing to you in relation to the email I sent to Councillor Rockfielding Mellon, the Cabinet Member of Housing and the Deputy Leader of the RBKC. And it goes on like that, about that. And the subject is the works to the smoke extract system and it deteriorating and in need of an upgrade to ensure compliance with health and safety. I'm summarising the topic. And then if you go a little bit lower down, you can see underneath the second bold sentence, it says, Ryden has been on site since June 2014, and so far there is no tangible evidence whatsoever Ryden and KCTMO intend to carry out replacement of the smoke vent and extraction and ventilation system, which links to the fire alarm. We need confirmation that Ryden will carry out the work as part of the regeneration project as promised by KCTMO. Now, we can see from what I've shown you so far, particularly the large number of recipients, that the email asked all recipients to pay attention to the email. Did you?
Yes.
Yes. Now, the concern being expressed here by Mr. Awaderu, as I say, is that although the FRA, the Fire Risk Assessment from 2012, November 2012, had identified the AOV system, the smoke extract system, in Grenfell Tower as in need of an upgrade, there was as yet no sign that Ryden had done it. And we'll come back to that in substance in a moment. Did you understand that the GTLA was at this point making a formal complaint?
Well, a formal complaint, I would understand this as a formal complaint. Whether the TMO would understand it as a formal complaint, it's a completely different issue.
Well, maybe, but I'm asking for your understanding.
Well, yes.
Yes, you thought it was a formal complaint. Who did you think it was a formal complaint to, the TMO or RBKC?
It should have been to the TMO.
Right. And given the long list of recipients, which you can see at the bottom of page 1 and the top of page 2, who did you think that complaint was addressed to as a complaint?
Well, that was the difficulty. I mean, I did speak to the Leaseholders Association and say that if they sent issues to everybody, it meant that nobody would reply.
And indeed, let's go up to if we scroll up a little bit, you can see at the top of the email chain, you respond to Emma Dent-Code, Councillor Dent-Code, the same day, 3rd of January 2015, and you say, oh dear, no, don't bother. I do not understand why they have to email absolutely everyone. Do you know why Ms. Dent-Code felt that she wasn't required to respond?
Because it wasn't in her ward.
I see. What was her role in dealing with concerns about Grenfell Tower?
Well, they were negligible because the Grenfell Tower was not in her ward.
Right. Why did you tell Councillor Dent-Code not to bother responding?
Because it was not in her ward.
Right. And now your reply suggests that you didn't agree with them emailing a large number of recipients.
Yes.
I think you've just explained this in your evidence just now, but could you humour me and just explain it again?
Because if you send emails to everybody, then everybody thinks somebody else is going to reply.
Did you think to respond to Mr. Awaderu and advise him of that?
I have told him that on several occasions, both face-to-face to Mr. Ahmed, face-to-face to Mr. Ahmed, and also certainly in one email I mentioned it.
Why did you think at the time that nonetheless the GTLA persisted in mass copying?
Well, it's probably just as well that they did, with the benefit of hindsight.
Because?
Because everybody was then made aware of the situation at Grenfell Tower.
But at the time?
At the time, I thought it was excessive.
Did you? Well, and you say you did advise him how better to get his message across.
Yeah.
Did you tell him, or did you give him advice along the lines of, look, if you really want to get this going and take it forward, you really need to send this to a focused group of people who actually will entertain the complaint formally?
Yes.
You did you? How did you do that?
That was to Mr. Ahmed, not Mr. Awaderu. Mr. Ahmed. Mr. Awaderu put his name to it because he was a non-resident leaseholder, and therefore I think Mr. Ahmed felt that he would not, if he signed everything, then they would go for him.
Yes, all right. Now, can we go to MET 304? Yes, 42201, please. Which is where you do see the advice you gave him. And you say, "Dear Tunde, I've asked the TMO for a response. I seriously suggest you not copy everyone into these emails. In any case, the list you're using is pre the 2014 council elections and is now very out of date. Kind regards and Happy New Year." Did Mr. Awadoa respond to you?
Well, I always wrote Dear Tunde because he signed the letters, but actually the emails came from Mr. Ahmed.
Right.
And I knew that. Mr. Ahmed knew that, and Mr. Ahmed knew that I knew.
Did the recipient of this email respond to you?
Don't think so.
Did the recipient of this email stop copying everyone into his emails?
No.
When you asked the TMO for a response, what did you do? Who did you ask?
I can't remember. Probably Peter Madison.
Right. How did you expect your inquiry to be, or complaint, I suppose, to be treated?
I may have just forwarded it to the TMO and asked for a reply.
Right. Did you expect the TMO to treat it as a formal complaint or as an inquiry, a member's inquiry?
As it was about services, it should have been treated as a complaint under their procedure.
Yes. And that's because is it that they were dissatisfied with the service provided by the TMO, namely the delay in replacing the AOV?
Yeah.
Yes. Can we go to MET 30s 42201, please? And if we go to page 2, this is a different. It's a different reference, but the same email, but lower down. And it's easy to see this one, which is why we've gone to this version of it. If you look at the second paragraph on page 2, it says, "Please find attached a scanned copy from KCTMA dated 30th of June 2011 in relation to the fire alarm and smoke extract system. For ease of reference, it states that the reason for the works in that the original fire alarm and smoke extract system are still in place and are deteriorating and in need of upgrade to ensure compliance with current health and safety legislation and continued operation. The work have been included in our capital programme. In a letter to me from the KCTMO dated 30th of January 2013 on page 2, it states, we can confirm that improvements will be made to the existing smoke extraction and ventilation system which links to the fire alarm under the Grenfell Regeneration Project." End of quote. And then it goes on, Ryden has been on site since June 2014, and I've read that to you already. It looks as if, is this right? The gist of the complaint is that GTLA had been told in 2011, or rather the TMO had been told in 2011 of the need for work to the fire alarm and smoke extract system, and again in 2013, but as at January 15, no work had been started on the smoke and extract system.
Hence the complaint.
That was the gist of it. So it was historical, going back 4 years.
Yeah.
Were you concerned to note that there had been a delay of 4 years to works to the fire alarm and smoke extract system at Grenfell?
I was concerned about all the emails that the Leaseholders Association sent me, and I sent most of them, if not all of them, on to the TMO for responses.
Yes, I understand that as a generic answer, but were you specifically alarmed to discover that the smoke extract system was not only not working and in need of an upgrade, but had been so for 4 years?
Yeah, I think I'd done a separate email to the TMO about the smoke extract system.
Were you aware whether the
Ventilation
fire alarm and smoke extract system was actually functioning at the time?
I think I was told that it was. I can't remember.
Right. Did you know whether the TMO had implemented any mitigation measures at Grenfell Tower pending completion of the works to the fire alarm and smoke extraction system?
I certainly asked for some mitigation works.
Right. What was the response?
I can't remember.
Can we go to TMO 1008422, page 1, please? So scroll up to the top of this email chain. We could see his response to your request for a TMO report on this matter, and it's dated it's dated 5th of January 2015, And after setting out the scope of the work for the refurbishment, halfway down the page he says this. You see, you probably can't see it on the screen. If you can just scroll up, please, thank you. Halfway down your screen it says, the scope of work to Grenfell includes the upgrade / renewal of smoke and fire safety and ventilation system. The system is currently beyond economic repair. We're working with building control to agree a design for the system that will meet current standards. We've been in close contact with the fire brigade to make them aware of the current situation so they can take this into account in their approach to any fire safety issues. Our contractors, Ryden, have also been in liaison with the fire brigade to agree safe working methods in the interim while the system is being worked on. We've posted notices throughout the building and explained in newsletters that a stay-put policy is in place in the event of a fire. Did you understand this message back to you to mean or indicate that the smoke extract system, the AOV system, was still working?
No, my understanding was that something had been put in place in the interim. This is an example of what I referred to, I think, on Thursday as bland responses intended just to reassure me and shut me up.
I see. So, although it says the system is currently beyond economic repair, nonetheless, what did you take from the last paragraph, which starts, our contractors, Ryden, have also been in liaison with the fire brigade?
Well, I understood that to mean that there were safety measures had been implemented in the meantime.
Right. Were you aware this time, and this is January 15, that the LFB had issued a deficiency notice to the TMO in respect of the non-functioning AOV system at Grenfell Tower in March 2014?
No.
With a cure date of May?
No.
5th of May 2014? No. Would you have expected Peter Maddison to have told you of that fact in his report to you here?
Well, yes. If that were the case, yes.
Did you expect Peter Maddison to tell you why there was a delay in carrying out the repairs to the AOV that had been pointed out to you in Mr. Awaderu's or Mr. Ahmed's message?
I thought this does reassure.
Doesn't explain why it had gone unaddressed for 4 years.
No, it doesn't.
My question was, did you expect at the time Mr. Maddison to have explained why that was?
Yeah.
But you didn't ask him to?
No.
Why was that?
Lack of resources, lack of time, as I explained. This was the point when the whole of Silchester Estate was being proposed to be demolished. And I had to deal with that too.
How did you take it? How did you leave this response? Were you happy with it?
I wasn't happy with it, but I accepted it. I realised I wasn't going to get anything else out of them.
Right. Can we then turn to the Grenfell Compact and the matrices that we looked at, or you referred to before? In your second police statement, which we've now looked at a number of times, can we go back to that, please? MET 3045751. You say on page 8, in the second paragraph there, following the refurbishment, I worked with 2 residents, Mr. Daffan and Mr. Thompson, and together we drew up a matrix of outstanding problems. This was sent to the TMO, and I requested regular updates. The matrix was a table highlighting some of the outstanding problems with a further column for the TMO and or Ryden to set out what actions they were taking to address the issues. Fire safety was an issue included in this matrix, and the fact that the stairwell hadn't been included in the refurbishment. I produced as my exhibit JB5 copies of the matrix from August 2015 and May 2016. Now, before we look at the matrices, Ms. Blakeman, can you explain how you, Mr. Daffan and Mr. Thompson went about preparing them?
Well, they told me what the problems were, and I put them into a matrix.
Right. Did you have a meeting with them?
Yes.
Right. You sat down with them and
Yes.
sketched it out.
Yes.
Did any other residents, other than Mr. Daffan and Mr. Thompson, contribute to those matrices?
Mr. Collins may have done. I'm not sure.
Yes.
Can't
In
remember.
fact, he says he did.
Okay.
But was it your understanding that these concerns were fairly representative
Oh, yes.
of the concerns shared by a large number of the residents of the tower?
Yes, otherwise I wouldn't have put them in the matrix.
Right. And what was it that gave rise to that understanding?
The number of complaints I'd had from residents.
What, separately?
Yes.
I see. So was it your perception that Mr. Daffar, Mr. Thompson and Mr. Collins, to the extent that he contributed, were reflecting what you'd already heard in the building or
Yes.
around the building?
Yes.
Yes. Now, let's look at the first of these matrices. This is August 2015. MET 30457662, please. And you can see, just to remind you how it's laid out, there's a number column and on the left-hand side, then resident issue in the middle, and then TMO straight right and response on the right. Now, from email correspondence, we believe that you sent it to Peter Madison on the 28th of August 2015, and the email is at MET 3070923. Just quickly look at that, just to pin that down in timing terms. Bottom of page 1, you to Madison, 28th August, and you attach the matrix. You refer to it and you attach it. Now let's look back at the matrix then, if we can, which is the last document. There it is, and you can see that if you go to page 3, a list of some 28 concerns or issues related to the refurbishment.
Yes.
Were you surprised that there were so many when it came to drafting it and numbering them?
No, I wasn't surprised because I'd had so many different complaints from residents.
Right. And if we go to number 22 on page 2, the last but one. We can see that there is an item there about alternative hot water facilities for washing. That's item 21. There's also an investigation into if you go to item 23, the floor numbering. Mm-hmm. Change floor numbers back to reflect current flat numbers and find an alternative numbering system for the 2 floors. Did you see that as a fire safety issue?
Yes.
You did. And you could
Well,
see
it was an emergency issue, not just fire safety, but any emergency.
Right. It's difficult, apart from that issue, it's difficult to see whether any of these issues were specifically fire safety issues. Is that right?
No.
Which of these would you have said at the time were intended to be fire safety matters? Take a moment to look through.
Well, can I see the whole document?
Yes, of course. Go to page 1.
Well, number 1 is a fire safety issue.
Right. Just cast your eye down page 1.
Number 6, I think there was, Mr. Collins certainly had a concern about HIUs in the hallway, which related to fire safety.
How did that relate to fire safety?
Because he was concerned that the boiler was put on top of the electrical incoming issue.
So the HIUs and possibly the floor numbering, which we've looked at. Any others? Do you
And
think?
the boxing of the open pipe work.
Yes, we scroll down a bit further onto page 2, perhaps. We can see, just casting your eye down the middle column, we've got more HIUs under item 14.
Yeah, 14 refers to the HIU one.
Yes. And then alternative hot water, which we've already looked at, which is also related to the HIUs in one sense.
Yep.
And then floor numbers at 23. And then on page 3, any of those related to fire issues?
Well, effective communication would relate to it.
Right. Looking at the response to number 23, at the bottom of page 2, just go back to that, change floor numbers back to reflect current flat numbers and find alternative numbering system for the 2 floors. The response was, Royal Mail requires the lower floors to be numbered so that the address is easily identifiable for the emergency services in the case of any incident. Floors have been renumbered and temporary signage fitted until the final version is available. The floor levels have been altered and it is not possible to revert to the old numbering. Were the new floor numbers easily identifiable for the emergency services in the event of an emergency?
No.
Why was that?
Because they didn't relate to the flat numbers didn't relate to the floors. You see, flat 1, 3, whatever would be on the 13th floor, but after the refurbishment, it was put on the 16th floor, and so on.
Was that problem not resolved by the temporary signage that the TMO put up?
No, because they just put up paper notices which disappeared or fell off or whatever.
Right. So
there was also an issue that in the stairwell, because the stairwell wasn't included in the refurbishment project, the door numbers on the stairwell didn't relate to the flat numbers any longer either.
right. And was the problem the actual renumbering of the floors, or was the problem the signage?
Oh, the renumbering of the floors.
Right.
But the signage didn't help
I
because it didn't. I mean, it was not. It was not permanent until quite late on.
Can we then go to TMO 1001093, please? And let's look at page 2 in this email run. This takes us to to early October 2015, and what I'm showing you is an email exchange you had with Peter Madison on the 2nd of October 2015. Very bottom of page 2, you write to Madison, 2nd October 15, copy to Claire Williams and other councillors. Sorry, received also by Claire Williams, copy to other councillors. Dear Mr. Madison, and then over to page 3, I'm writing to let you have the issues raised with members of the Grenfell Tower Compact at last Saturday's surgery with my colleague, Councillor Atkinson, in advance of your meeting next week. They are as follows. And then you set out a long list of items. Just before we look at those, you, I think, weren't present at the Saturday surgery, were you?
No.
Why did you write to Peter Madison and not Councillor Atkinson?
Because Peter Madison was the person to deal with the complaints.
I see. So this was part of the complaints process.
Yeah.
I follow. If we go to page 3, we can see that you, as we can see, list a large number of items of concern from residents. And at point 6, you say this: they continue to have an issue with the numbering of the floors, as do the ward councillors. Whatever the post office requires, the new system.
Just a minute, exactly.
I'm so sorry.
We can't see 6 at the moment.
You can't. I'm so sorry. That was.
There we are.
I got ahead of myself. Paragraph 6. I'll start it again. They continue to have an issue with the numbering of the floors, as do the ward councillors. Whatever the post office requires, the new system of numbering is not effective and could prove dangerous in the event of an emergency. The notices about the floor number changes are not prominent or secure, and in any case would not be helpful to children, anyone who does not read English, or indeed anyone with literacy problems. The solution the residents propose is that the lower floors should have a new name, such as Lower Grenfell. We believe that this issue does require some further consideration. Now, although you weren't present at the meeting, what did you think the residents meant when they said that the new system of numbering could prove dangerous in the event of an emergency?
Because it could mean whoever was dealing with, from the statutory services, whoever was dealing with the emergency might go to the wrong floor and might be delayed as a result.
Do you know if any residents reported any concerns about the floor numbering themselves directly to the TMO?
Well, they may have done, but residents used to, particularly those whose first language was not English, liked to ring up with their complaints. And then when their complaints weren't addressed, they would come to me and say, well, I rang and nobody... And I would say, well, you need to put the complaint in writing. And they didn't like to, because I entirely understand, because they don't like writing in a strange language. So I said, well, come to me then. I will put the complaint into writing for you.
I follow. So is this an example, then, of the kind of complaint that some residents of the tower could in effect really only make through you.
Yes, I mean, there was no mechanism for collective complaints, only for individual complaints.
Indeed. And for some individuals, as you've just said, you were the only conduit. And
Well, I wasn't the only conduit. The compact was as well, and other residents.
Yes.
But certainly those who came to me and complained that their complaints had not been dealt with, I would say, well, did you put it in writing? Yeah. Otherwise, these things can be lost.
I follow. And then looking at paragraph 7, you say they would like another independent inspection of the arrangements in the event of a fire. Perhaps this might be better carried out at the end of the project, although I think they have concerns about what would happen during the works in the event of a fire, especially because of the floor numbering problem. This request should also receive further consideration. When you say another independent inspection of the arrangements, were residents aware of a previous inspection?
Well, I had asked on behalf of the Leaseholders Association some years before this for a fire investigation, and I was told that the LFB had carried one out. Now, whether that was communicated to all the residents or not, I can't recollect.
Right. Was that the LFB visit in 2013?
Could have been. Whatever it was in response to a request I submitted on behalf of the Leaseholders Association.
Was it the leaseholders who were saying another independent investigation, or was that your word?
No, that was my word.
I see. Do you know what specific concerns caused residents to ask for an independent investigation of the arrangements in the event of a fire?
I think that was post-Lacanau, and the recommendations from the coroner included a statement that after a major refurbishment there should be a full independent assessment of fire safety matters.
And what was it in 2015 that had prompted the residents to ask for another independent investigation?
No, I asked for another. They asked for an independent investigation.
Sorry, you're quite right, and you corrected me. What was it that prompted them to ask for an independent inspection of the arrangements in 2015?
Because of their concerns.
About the numbering?
Yeah, well, not just the numbering, but yeah, the whole thing.
Why did you think it was better to carry out an inspection at the end of the project rather than...
Well, that was because of the coroner's report, but I also felt that perhaps one during the works would have been advisable. But I think I did separate emails about those, and I was told that the LFB came regularly to Grenfell Tower.
Now, if we go up to page 1 in this email run, you can see Peter Madison responds to you the same day. And he, unfortunately, his response, although it's in red in the original, appears black in the electronic copy we've got here. And doesn't come up. But if we go to the top of page 2, we can see item 6. And the very last sentence, which says, "We will review this again and come back to you." It's in red in the original. You can't see it. It's in black. And in item 7, the last word there is agreed. It's in black, but was in red in the original. Those were his responses. He, as I say, appears to have responded promptly and positively to your concerns under items 6 and 7. Was that how you saw it at the time?
Well, I think he did come back to me with regard to the floor numbering and said no, and said it was a responsibility that the Royal Mail had insisted, as he had said previously.
Well, he doesn't though, does he? He says at the end of 6...
Yeah, no, on a separate email exchange.
Yes. But on this one, he says...
On that one, he says, yes, we'll review it again and come back to you. And then he did come back.
Right. Yeah,
but that was in a separate email.
It is, and we'll come to that. But at this stage, Ms. Blakeman, were you mollified? Are you happy with his answer?
Well, I would await his formal response.
He didn't brush you off straight away at least? No. Did you ask at this stage for a copy of the existing fire risk assessment for Grenfell Tower?
No.
If we look on, we then get to TMO 1002547 which takes us on a little bit later in the same month. This is now the 18th of October 2015. We can see here that you are, in the second email down, writing to Robert Black on the 18th of October. Dear Mr. Black, you say, I'm writing to let you know that the Nottingdale ward councillors are coming under great pressure to ask for a full report on the refurbishment process at Grenfell Tower to be written up for an in-depth discussion by the Council's Housing and Property Scrutiny Committee. We're very sorry about this because we'd hoped that after recent meetings attended by the ward councillors, things had calmed down and we were now making progress. But we certainly agree with some of the outstanding matters that continue to be raised with us. These include the following, and then it goes on. Why did you email Robert Black directly?
Because he was the chief executive and I wasn't getting anywhere with Peter Madison.
Right, I see. And who was putting pressure on you for a full report?
The residents.
Were many residents at Grenfell putting pressure on you to obtain a full report?
Yeah, this is following the meeting that we attended, which was held in the show flat. There were a lot of residents there.
Was that in October? Or was that before?
I can't remember. I think it was before.
Yes. Why were residents asking for the report to be discussed at scrutiny, the RBKC's scrutiny committee?
Presumably because they felt that the HPSC had more influence over the TMO than I did.
I follow. Was there any discussion at this time about raising these issues with the TMO board?
No.
Did you suggest that the issues that had been raised with you by the residents, such as in the matrix we've seen with the compact and such as we've seen with the email that's come to you, and that you've reflected in the numbered list we saw you sent, discussed at the board?
I think they'd been discussed at the board and I'd got nowhere.
Right. Can we go back to your email then, please? TMO 1002547 just think it's still on the screen. Mm-hmm. And lower down from where we were, if you look at the third paragraph, you raise a number of concerns. And in summary, they are an investigation into Ryden contractors bullying residents. That's the paragraph that starts, Mr. Lawrence of Ryden gave a firm undertaking. And then if you turn the page, after some discussion of the HIUs, you can see that on page 2, there's also discussion in the middle of page 2 of the floor numbering. You say less serious, it's the bottom of your screen, less serious. Now it's in the middle of your screen. Mm-hmm. Less serious, but of great concern is the numbering the floors. For a long time, both residents and ward councillors were told that this was under instruction from the Royal Mail. However, residents used the Freedom of Information procedures to obtain a categorical denial from Royal Mail that they had insisted on this. Residents were then told that this was an instruction from the planning department. I'm very concerned that both councillors and residents were misled. I've also checked the planning applications and can find no reference to floor numbering. There are always alternative mechanisms for floor numbers when new ones are installed that do not need to disrupt a whole block, certainly not one of the size of Grenfell Tower. And then further down to the end of your email on page 3, in the last 2 paragraphs, you say this: I apologise for the length of this email, but I'm afraid that both residents and ward councillors are at the end of our tethers. Residents fear that direct action is again becoming the only option for them. We would not like to encourage this, but we can see their point. We get regular deputations now to all our surgeries. We can only provide residents with the information that we have available. This puts us under pressure if we're given misleading information, and also if we're seen to be aware of matters, such as completion dates, that have not been provided to residents. Now, you don't mention here that you thought the new numbering could cause confusion in the event of an emergency, which was the point that you'd raised at item 6 in your 2nd of October email earlier in the month. Was that because it was no longer a concern?
No, I think it was because we'd already raised it.
Right, but you don't repeat it?
Well, I mentioned that Royal Mail had denied
right.
involvement, and they'd gone to the planning department. We couldn't find anything at the planning department that required it. So it remained outstanding.
It remained outstanding. And was your main concern at this point the actual renumbering, or was it, by this stage, the signing, the signposting?
Well, it was the whole thing, that everything that's set out in the email.
And you say that the TMO had misled you about the decision-making process for renumbering the floor numbers. Had you lost confidence in the information that the TMO were providing you at this point?
Yes.
By this time?
Yes.
Who do you believe it was that had misled you?
Well, Peter Madison was my main point of contact. Claire Williams and Peter Madison were my main points of contact, but they were presumably acting under instructions from their superiors.
Did you ever get to the bottom of this Royal Mail point?
No.
It's quite a serious allegation that you've made here, that councillors and residents were misled.
Yes.
Did you ask Robert Black to investigate?
Well, one would assume that, as I'd written to him, that he would.
You assumed it. Did you actually ask him to undertake an investigation?
I can't recollect.
Did you ask the rest of the board, as a board, to require Mr. Black,
No.
to undertake an investigation? Why is that?
Because there was no point my raising issues at the board.
Did this problem about the Royal Mail point cause you to doubt any other information provided by the TMO to you about the refurbishment?
Well, it could have set a precedent. I didn't know.
You say that ward councillors and residents were at the end of our tethers.
Yes.
What did you mean by that?
The fact that everything we raised, we'd just get kicked back on.
And why did you understand that residents who thought direct action was the only option for them? Why did you think that was the case?
Because some of them may have told us that.
You refer to regular deputations to your surgeries. Do you know who attended your surgery from Grenfell Tower?
Well, we didn't take names, but quite a few people came.
And that was the experience, as far as you could see it, for the other councillors?
I think so, yes, because I think this email was based on something from Councillor Atkinson, so he obviously had the deputation as well when he ran the surgery.
Right. Now, moving on with this subject, we next go to a report drafted by the TMO in response to this email of yours of the 18th of October 2015. It's at TMO 00831964. I'll just put it up for you, first of all. TMO 00831964. Yes. And it's entitled Investigation into the Issues Raised by Councillor Blakeman in her email dated 18th of October 2015. And we'll come back to look at the body of it in a moment. Just to be clear, this was sent to you, it seems, on the 26th of October 2015 at TMO 00852632 at page 2. Just to be clear that you did get this. If we look at the bottom of page 2, Sasha Jennings writes to you on that date, 26th of October 2015, copy to Robert Black. Dear Councillor Blakeman, Robert has forwarded your email for my response. I attach a full reply to the issues that you've raised, and also attach copies of the Grenfell newsletters for your reference. And then Peter Madison is available to meet with you at 2 p.m. on Friday, 30th of October. I'd be grateful if you could confirm that this time is acceptable. Now, let's go back to the report that Sasha Jennings sent you on the 26th of October 2015 at TMO 00852632. Sorry, TMO 00831964. There it is. That's the first page. Can we go to page 4 in that, please, where we can see the subheading Changes in Floor Numbering? And we'll focus on that specifically. It says, the proposed changes in floor numbering were initially communicated to residents in the newsletter of February 2015, copy attached, and subsequently in the April 2015 newsletter, copy attached. In our April 2015 newsletter, we reported the following: 2 postal addresses When the new flats in the lower floors are finished, they will need postal addresses. We've applied for these from the council, who are liaising with Royal Mail. The Royal Mail requires the lower floors to be numbered in case the emergency services need to visit. This means that all the floors will have to be renumbered and temporary signage will be installed until the final version is available. While it does not affect your address, we apologise for any difficulties this may cause. This clearly states that we were working with the council, brackets planners, brackets, who were in liaison with Royal Mail about the numbering of the new flats and the floor numbering. This gives an explanation of the respective roles of KCTMO, the council and Royal Mail in this matter. It was the council planners who informed us that the floors should be numbered in the way we have now implemented. We have taken the planners' advice in good faith and acted on it. I do not agree that residents or councillors have been misled, as Councillor Blakeman suggests. And then it goes on. The new floor numbering went live in May 2015 when the lift service was reinstated, following the creation of the additional lift stops at new levels 1, 2 and 3. Residents have been using the new numbering since this date, and we have not received any correspondence or complaints until the matter was raised by Mr. Collins in August 2015. And then there's a page 5, bullet point summary of why the TMO was rejecting your allegations. Now, as I've shown you, the report suggests that the TMO did not mislead you and that the suggestion came from the council to amend the floor numbering. Did that in particular, or perhaps more generally what I've read to you, allay your concerns about the information provided to the residents?
Well, it was difficult to understand by then what was going on, because initially we told it was the decision of the planners to change the numbers. When I queried that, I was told no, it was the decision of Royal Mail. Then the residents said that they'd used a Freedom of Information request to Royal Mail, and Royal Mail had denied that it was down to them. So I was very, very confused as to who was responsible, and, well, the TMO said that.
Did you take them at their word?
No.
Why is that?
Because the residents had been to Royal Mail under the Freedom of Information Act.
But did you go back to Mr. Madison and say, I'm very sorry, this doesn't add up, because here we have the Royal Mail's response, and it's inconsistent with what you're telling me?
I can't remember.
I don't think we've got a record of you doing that.
Okay. Well, I've probably given up by then. Because I wasn't getting anywhere.
As I've shown you at the bottom of page 4, there's the reference to the new numbering and the lifts, and there being no correspondence or complaints until it was raised by Mr. Collins in 2015. That suggests that Mr. Collins was the only resident who had concerns about the floor numbering.
No, Mr. Collins was the chair of the compact, and residents would have complained to him.
Well, I was going to ask you, that was the question. Was it correct that Mr. Collins was the only resident with such concerns?
Well, he would have been putting the concerns on behalf of residents as chair of the compact.
The response doesn't appear to answer your concern expressed in your item 6.
No.
That the new numbering could prove dangerous in the event of an emergency.
Exactly.
Did you go back on that point?
No, I mean, as I said, I'd probably given up by then because I was just getting the same old nonsense.
Right. If we go to TMO 0085263 please. TMO 0085263, page 1. This is an email exchange between Laura Johnson and Sasha Jennings on the 2nd of November 2015, shortly after you were sent the 18th of October response on the 26th of October. Now, you, of course, were not copied into this particular exchange, but let's see what Laura Johnson says. In the middle of your screen, I read this and actually felt really sorry for Peter and the team. This is a really good project with loads of positive outcomes for the residents, and due to the negative stance taken by a minority on various details, the project is made to feel no longer like the success it actually is. Officers and Councillor Fielding Mellon take a different view from Councillor Blakeman. We acknowledge that there has been problems, but overall, apart from the non-controllable issue of companies going into liquidation and slight overrun in finishing, it's gone really well. We shall celebrate when it's finished. The children go to the new nursery, kids are boxing in a fabulous new gym, and people are living in lovely warm flats. Did you agree, just with that sentiment, that it was a minority of residents at Grenfell Tower who took a negative stance?
Not by then, no.
Not by then being November 15?
Yeah.
Right. Were you aware that RBKC officers and Counselling Fielding Mellon took a different view from yours on the refurbishment?
All the time, yes.
Right. In your view, was it going well?
No.
If we go to the top email, we can see that Sasha Jennings says to Laura Johnson by way of response, same day, 2nd November 15, "Hi Laura, thanks for your positive comments. I met with Councillor B on Friday and we went through more detail. I then took another look around Grenfell and it is really looking good. It will be great when it's finished." Do you remember that meeting? Do you remember meeting Sasha Jennings?
Too long ago.
Too long ago. Do you remember meeting any senior operations executive from the TMO to discuss your continuing concerns?
I think so, yes.
You do think you did?
Yeah.
Let's be more specific.
Well, I mean, I can't remember that far back.
No. Did you remember discussing the 18th of October response to your email with anybody at the TMO?
I can't remember.
Right. Do you remember having any discussions with the TMO about continuing questions that you had about the fire safety of Grenfell Tower at this stage in the refurbishment?
I can't remember.
Now, we've seen no response from you to the 18th of October report sent to you on the 26th of October 2015. Did you respond, do you think?
I think I may have responded to Laura Johnson because something was sent out that they wanted me to put my name to, and I refused to put my name to it.
Did you take the report that had been sent to you on the 26th of October 2015 back to the Grenfell Compact?
I probably would have sent it to them, yes, but I can't confirm that one way or the other.
Right. How would you have done that? By email or
Yes.
by email? And do you remember what the reaction was from the Grenfell Compact?
Well, I can't remember whether I sent it or not. So I can't remember whether there was a reaction or not.
Now, turning to a slightly different topic, and I may come back after the break to follow up on one or two aspects of the evidence you've given just now, just to trace down one or two documents. But moving on, if I may, can we go please to RBK 30's54461? At page 17, this is your statement, and you say at paragraph 91, thank you. As residents became more and more frustrated and feeling that their concerns about the refurbishment and fire safety issues were being ignored, I suggested that they submit a petition to the HPSC. I worked with them on the prayer of the petition and submitted it to the full council meeting in December 2015. This was then considered by the TMO, and I exhibit as JMB 26 a briefing note on the petition that was sent by Sasha Jennings to the TMO board in advance of a TMO board meeting on 4th January 2016. The petition was then discussed at the Scrutiny Committee meeting on 6th January 2016, and I produced the minutes of that meeting, at which representations on behalf of the Grenfell Tower residents were considered, as my exhibit JMB 27. Now, the idea to submit a petition to HPSC appears to have come from you, is that right?
No, Mr. Defan asked me how on earth we could get the issue discussed by the Housing and Property Scrutiny Committee, and I said probably the best mechanism would be through a petition to the council, because unless it had over 1,500 signatures, which it wouldn't have, it would be referred to the relevant committee.
Did you tell Mr. Daffan that you had had a full response, or what looked like a full response, by the TMO to your concerns as set out in your 2nd of October email?
Well, whether I said that or not is irrelevant, because I didn't consider it was a full response. It was more of the bland nature of reassurance rather than actually dealing with the issue.
Did you show Mr. Daffan the 18th of October response?
I don't know. If I copied it to the compact, he would have seen it. I don't know.
Right. Why did you mention a petition to Mr. Daffan as a possible route, given that on the face of it, on paper at least, the TMO had provided an answer or a purported answer to your points in the 18th of October document.
Because that clearly, whether they saw it or not, it was clearly not satisfactory. And concerns remained.
I don't think we've seen a record of you going back to Peter Madison or Sasha Jennings and saying this 18th of October defence document, response document is unsatisfactory.
No, I probably gave up by then.
Right. So having given up and left things left on paper, at least as they were, why not at least tell Mr. Daffan that you'd had a response from the TMO, this was it, you didn't regard it as satisfactory, and focus the petition on the defects as you saw them in that response?
I can't recollect. I mean, that's an impossible question to answer.
Well, is it? I just wonder why that's so. Because if you were,
if I had sent,
let me put the question to you, if I may. If you were unhappy with the TMO's response, which was sent to you in late October, and identified flaws in it, then the question is, why didn't you either bring those flaws to the attention of the TMO by way of riposte, or advise Mr. Daffan that he should do so as part of the petition process?
well, there was no point advising Mr. Daffan to do that, because he would have had even less authority than I. And he asked me what is the best way to get the Housing and Property Scrutiny Committee to discuss these issues. And I said, probably through a petition.
Was it usual for residents to raise concerns through a petition in this way?
Well, I'd raised the power surges through a petition as well.
I see. So there was a precedent for it.
Yes.
And why did you suggest they petition the HPSC in particular?
No, it was a petition that's submitted to the council. If it has more than 1,500 signatures, it is considered by the council. If it has fewer than 1,500 signatures, it goes to the relevant appropriate committee, which in this instance was the Housing and Property Scrutiny Committee.
Yes, I see. Thank you.
Which was the intention of it.
Yes. And what outcome were you hoping to achieve?
I was hoping, to an extent, the committee did consider it. They didn't accept the need for an independent investigation of how the refurbishment had been carried out.
Indeed, and we'll come to that. At this point, so early December 2015, can you remember what fire safety issues were still occupying residents' concerns?
Not offhand, no, but I'm sure you'll show me.
Let's go then to the meeting itself, 6th of January 2016, RBK 3032130. This is the minute of the meeting of the HPSC on that date, and we can see who is present.
Yep.
You are present as a member.
Yes.
Along with Mr. Marshall and Mr. McAver, Councillors Marshall and McAver, and Robert Black's in attendance. Now, on page 2 of the minutes, we can see the agenda item 4, A4, Grenfell Tower, verbal item. And it was a verbal item, as I understand it. Is this right? Because there was going to be discussion?
It was a verbal item, presumably, because they didn't want to put things down in paper.
Right. Well, what does verbal item normally mean in RBKC parlance?
I think normally it means either that there wasn't a paper ready in time for circulation, or that they don't want to put something down in writing.
Right. Was it identified as a verbal item at the meeting, or is that just a...
Yes, and on the agenda that was sent out before the meeting.
I follow. Now, as we understand what happened, looking at this document, Laura Johnson presented the issue that Grenfell Tower had been completed, the refurbishment had been completed, and on page 3, you could see at the top of the page that Edward Daffan, lead representative of the Grenfell Tower Residents Association, was given an opportunity to address the committee. That's how it's recorded.
Yeah, I think he was cut short before he'd finished.
Yes. And let's just look at the note for the moment. He's described there as the lead representative of the Grenfell Tower Residents Association.
He was one of the lead representatives. I think they'd set up a committee.
Right. Was it agreed or understood that he would be speaking for the residents of Grenfell Tower?
Yes.
Right. And at the bottom of the page, and let's just take it a bit more slowly. We can see that he highlighted 6 main issues in his representation, and they're numbered there. Lack of consultation and residents' engagement, boilers being placed in hallways without consultation and warning, residents experience threats, harassment, lies and intimidation, lack of response to legitimate complaints, poor workmanship and site management, and compensation. Concluded that there was a need for urgent scrutiny of the management of the works that had been carried out, which needed to be conducted as an independent investigation. He said residents had been belittled, ignored, or sidelined, and their day-to-day concerns downplayed. He said that it was vital that lessons are learnt for any future works and the problems experienced not replicated. A copy of Mr. Daffon's full statement has been placed on the minute book. And then we see that you are recorded as saying something, and it goes like this. Councillor Blakeman said that it was important that an examination of the project be conducted so that the council could learn from the experiences of the residents of Grenfell Tower. She said that there had been a mismatch of information between what had been reported and what the residents were actually experiencing. She said that the newsletter sent to residents in relation to the boilers had been incomprehensible and the residents would not have understood the importance. Councillor Blakeman reported that there had been 2 babies born during the works that had special needs and no respite was provided for these families. She said that a number of individual complaints had been submitted but had not been responded to, and this may lead to residents approaching the Housing Ombudsman. She said she could provide specific examples where required.
Yeah, can I make the point that the babies didn't have special needs? They had special needs as newborn babies, in case that's misunderstood.
I had actually understood it differently, but that's very clear. Now, I pause there. Were you referring, when you say that there had been a mismatch, to the TMO survey conducted in December 2015?
No, I meant a mismatch between what the newsletter said and what residents actually experienced.
Well, I'm asking you about this because it says mismatch of information between what had been reported.
Yeah.
And I'm asking you, what was it that had been reported?
Well, I go back to the bland reassurances that I was given that weren't actually happening.
So you weren't referring then to the survey which had been referred to?
Well, that was one issue.
Right.
But only one.
Mr. Chairman, is that a convenient moment?
Yes, I think it is. Thank you, Mr. Millett. Well, we'll stop there for some lunch now, Ms. Blakeman. We'll resume at 2 o'clock, please. And please, would you not talk to anyone about your evidence while you're out of the room?
Sure.
All right, thank you. Thank you. 2 o'clock, then, Mr. Millett.
Yes, thank you very much, Mr. Chairman.